pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Can we pause just one moment and get the video up? Can you hear us out there with microphones? Not much.
No.
It's pretty quiet. My Wi-Fi disconnected and I need my password. Okay. Already. You guys can all have a seat up here, wherever. Thank you. Have a seat.
We're good.
I would like for you to have a seat, please. Well, maybe you don't want, maybe they don't want to.
Understand, in case they get called out for fire call.
Whatever.
Yeah.
It would make us more comfortable if everyone had a seat, please.
I'm not gonna sit down.
I'm a retired police officer, I'm not gonna do anything to you, don't worry about it.
I am so sorry for this delay. Apologies. I asked something to come, I don't know if they came or not.
I think we're working on the microphones right now.
I'm working on the internet right now. Sorry. Trying a different internet connection. I am so sorry, everybody.
We've got red lights, is that?
Yes, it's encouraging.
Yeah.
No, go ahead, you're fine. Okay, my apologies to everyone online and in the room for that delay. I believe we're online now. We're recording, we've got video. All right. Apologies for that delay, ladies. Yeah.
I'm serious, I don't
Just let us stand.
stand all, I mean, I see all the time. I mean, we're not making some big deal, I just want to say.
No. All right, apologies to everyone online. Okay. Nancy, if you're ready to start, go ahead.
Okay,
For Nancy.
yeah, we'll wait for Nancy Jo. First item will be to approve our agenda for tonight, so I would ask for a motion,
I'll make that motion.
okay, John. Do I have a second?
I'll second that.
Scott. All in favor, say aye.
Aye.
Opposed? I'm sure Nancy's fine with it too. Next item is to approve the minutes from our July 16th, 2025 meeting. Laura has provided us with a copy, and I think we've all had a chance to read through those. So again, I would ask for a motion to approve the previous meeting minutes.
I make a motion to approve the previous minutes.
Scott. Dave seconds. All in favor, say aye.
Aye.
Opposed? Motion passes. I have an opening statement, and I'm just gonna give Nancy another few seconds here before I would address the group.
While we're waiting, some of you came in a little later. We do have two separate sign-in sheets for comments. We have one for Manatt, which we'll be presenting first, and one for Salt Creek Wind 2. If you think you may have signed the wrong one, or you'd like to still come add your name, you don't need to sign in unless you're planning to speak, just so I have a record of who's speaking for the public hearing. Everyone is welcome. We're gonna have 3 minutes per person for public comment here. And if you change your mind and you wanna comment later, you're very welcome to add your name at a later time.
What happened to citizens' rights?
Are you kidding me? Are you serious?
Citizens have rights.
Goodness gracious.
Okay, I am gonna go ahead and make my opening statement here, even though Nancy, is not yet seated. Good evening. For those of you who don't know me, I'm Nancy Houston, Chair of the Tama County Board of Adjustment. Thank you for your attendance. Tonight, we'll be hearing 2 requests for conditional use permits. First will be a CUP application to build and or use a temporary portable asphalt plant within Wendling Quarries. The second will be a request for a CUP for 27 wind turbines and a CUP for 1 substation for Salt Creek Wind 2. I want to sincerely thank the board members of this board, to my right and to my left, as they are some of the very best citizens in Tama County. Thank you for the countless hours you've spent in reading and understanding this complex Salt Creek CUP application, along with all the appendixes and studies. I could not ask for a better 5-member board. I want to thank our zoning administrator, Laura Wilson. Laura graciously copied for each of the 5 board adjustment members the full application, which filled these 3-inch thick binders. Laura has been extremely thorough and precise in her role, and she has been willing to go above and beyond in her capacity. By spending her own time outside of the office, unpaid, to make sure all tasks and requirements have been attended to. She has been exemplary in this capacity. Our attorney, Mr. Tom Henderson, has also been readily available and fully willing to assist this board with any and all questions we've had, and we all very much appreciate his professionalism and legal expertise in assisting us through this process. As tonight's agenda identifies, time limits have been set for the applicant presentations, public comments, and applicant rebuttal to public comments. All comments are to be addressed to the Board of Adjustment. If you run over your allotted time and are close to completion, please ask for a brief extension of time. We have much information to cover tonight, so I want to be mindful of time constraints that allow everyone present to feel they are important in this process and have been heard. Public comments will be limited to only addressing the conditional use permits we are hearing this evening. And with that, we're going to be starting with a cup application from Manatt, and Laura Wilson, zoning administrator, will present a report on the application to the board.
All right, I had received a lot of information ahead of time. We did get this nice PowerPoint presentation they'll be presenting tonight. However, from the application, what I've seen is we do allow asphalt plants in heavy industrial districts, and Wendling Quarries, Montour Quarry is a heavy industrial district, so that is allowable with a conditional use permit. As long as their setbacks match what the setbacks in our ordinance say, those are not included with the cup application, so as long as we make sure those are adhering to the ordinance. From what I've seen so far, I would recommend at this time to approve with a condition of including a ending time limit. I know they said they have a project timeline for this. I would just like to have that in writing, what their estimate is in your condition, and any other conditions you feel may be important. I did get one comment secondhand through a supervisor, and if that person does not speak tonight, I will share that later when we get to public comments. So that is my report and recommendation from the Nats.
Okay, good. And so you're the gentleman that is going to present tonight?
Brian Walker, the general manager of Asphalt.
Brian Walker.
We're just asking that you guys grant us permission to put our portable asphalt plant in Wendling Quarries. We'll abide by the setbacks. The locations. We'll be paving the E66 project between Highway 30 and Highway 21 down by Chelsea. The paving project has started. The cold in place recycling has been done. Yeah, effectively looking to move in first week in November. Tentatively, finish the first week of December. There's about 30,000 tons of asphalt to be placed out of that plant. There's the site location. Generally, not super clear, but this first construction driveway would be our access and egress, and then we just take the gravel south out to Highway 30 to be our haul route. There's the project location. That would be the reason for placing the plant at Wendling Quarry site. Suitability for location, I mean, we're sitting right on our rock source. Noise, we're kind of out in the middle of nowhere, and the corridor has a pretty substantial noise footprint already. Dust be controlled through watering or calcium chloride in site. The plant is temporary, will be dismantled upon the completion of the project. Just fits well. Wendling Quarries and Manatt are subsidiaries of one another, so it's all one big happy family. That's it.
Okay. And now we will move to any public comments, 3 minutes each, if anyone wants to speak about this application.
I don't have anyone on the list. Does anyone want to comment after the presentation? In that case, the one comment I did get secondhand through supervisor was concerned about hours of operation. They said at a previous project or what they're currently doing in the quarry, it wasn't clear. They didn't talk to this person directly, but they were concerned that hours of operation were running quite late. So I don't know if that's something we would like to consider as a possible condition, is managing that.
What are you thinking, Brian, on hours?
I mean, generally we have a half hour before, or after sunrise and a half hour before sunset. The E66 project is a closed road, so we will have a little bit more leniency in the construction hours.
So when you said half hour before,
So our general construction hours on highway are a half hour after sunrise to a half hour before sunset, that's when we can technically be on the road.
So you're working with the sun?
Yeah, but since this is a closed road, we're gonna stretch those hours a little bit. Like I said, we really wanna get this project and, Ben would also really like us to get this project done in the county this calendar year, so.
so really that December end date is, you got some wiggle room in there.
It should, the 25 days that we're kind of planning on sitting there should be more than adequate, but Mother Nature throws a wrench in things. You know, it's kind of, if we get some rain days or something like that, it might need to stretch a little bit further than that. We kind of gave ourselves a little bit of cushion, but not more than the weather this fall.
Anybody else have questions?
Is there a certain temperature it gets to that you have to quit? I mean, December 3rd,
Yeah, I mean, if we get
enough?
consistently road temperatures below 40, that'll bring us to a screeching halt. But that's surface conditions, not necessarily air conditions, so that actually works in our favor. Things stay warm, a little bit longer on the roadway than they would otherwise, so we can squeak a little bit longer time out of it.
And so how many miles would you be traveling with asphalt?
So I'm not even positive, it'd be basically from the corner of T47 into Montour to the E66 exit.
Do you have an estimate?
What that is it 50 miles? Probably.
10 or 15?
Yeah.
And has the quarry ever had a temporary asphalt plant in prior years?
Yeah, we've sat in there. The 30 years I've worked for Manatt, we've almost been in there, I'm not gonna say annually, but probably every other.
Oh, every other year you
Yeah.
do this?
Yeah.
And is it the same footprint on the quarry?
Yep, we've got a concrete footing board that we sit on every time, so. Right inside that gate, there's a pad that we sit on.
So every time you've come before the board of adjustment to get
I've
it?
never been asked to before.
This is a first.
Yeah. It's been a lot first. When we, yeah, this year is the first year, Clinton County asked us, Benton County did not. It's been county to county, whether they, usually it's south when we apply to the DNR for air and water quality permits, which those are done way before we come and see you guys. But, this is, yeah, it's been an unusual year. A lot of counties have requested it for the board of adjustments and some don't care.
Yeah.
Anybody else here on the board have any questions for Brian?
No, I don't have any questions for you.
None for me.
And for me,
Okay, well, we will proceed then. Does anyone, before we would vote, would you have any conditions that you would want to place on it? If you vote yes, would you have any condition as to, stretching that end date by a couple of weeks? I mean, I don't know what's appropriate.
I mean, what do we do if the weather doesn't get bad and they have to shut down until next spring?
That would be the only caveat. If things went horribly wrong with the fall, we would technically winter the plant there and then take off.
if we had a snowfall or something and then all of a sudden it got warmer again, would you continue on then?
Yeah, I mean, I have every intention of
Yeah.
finishing that project this year. I really want
Because
to.
the road is probably gonna be closed.
Yeah.
It is closed. The detour will go up. I might have went up today. Yeah. The detour went up and that'll be,
So the whole road from 30 to 21 will be closed all at one time.
So December 3rd, do you want us to push it back a couple months to make sure, or are you okay with that? We know you're gonna get it done, we know you wanna get in there and get it done.
I guess if you don't mind pushing it back, just in case, I feel like probably I'll have to, unless you're gonna okay it through the spring, like through March or May of next year.
To me, that would be my opinion, because they're not gonna tear it down.
No, it would just
They're not
slow all
gonna come
things
back
and
in the
cease production.
spring
I mean, that would be,
to finish it, which I'm sure you'll get it done ahead of time, but
yeah, I mean, like I said, we have every intention, but if Mother Nature throws a wrench,
yeah.
we'll get it to a point where the county's satisfied with passable, it just won't have the surface course completely finished by until next spring if we run into weather issues. Probably 15 days of paving, we would be completely done down there. It's just picking right 15 days this time.
Didn't take you long to do the grind and let it cold back down.
No, it was pretty quick, so, I mean, it's a nice little project for us to finish out the year, it's just, full transparency, this job was led by the DOT in June, with a September start date. Those things never happen, because the DOT had some money left over, so they had about 70 million to burn towards the end of the year, so they had a lot of bookshelf projects. They just said, here, let's get these out there, and they had to book those projects before July 1st for their new fiscal, so. Not the norm, I've never seen it before happen like this, but that's what they did, so.
Well, so, I will have a roll call alphabetically, and if we wanna have a condition after the vote, we can certainly do that, but I will start out, roll call alphabetically. David, yes or no?
Yes. Aye.
Nancy?
Yes.
And Scott?
Yes.
And John?
Yes.
And I am a yes as well. And, the only condition I would say is maybe, that December 3rd, rather than have it on there just until project is completed. I guess, I would feel comfortable with that.
I would agree. Yeah.
The asphalt plant is gonna be temporary at Manatt until the DEC. I'm sorry?
It's your.
Somebody just joined and I think they're echoing.
Oh, okay.
We can hear our voices.
Oh, wonder if he's further away.
They just muted, I think.
Okay, good. All right, so, it looks like, you have been approved for the conditional use permit, and I believe I have paperwork here that we're gonna have you sign.
We're gonna take a short recess before.
Yeah, we are gonna take a 5-minute recess, before we start with the Salt Creek Wind 2 cup application. So, do we all have these? We all have, yes.
You all have a yes or no of why you decided to vote your way.
Yes.
And then I have one for me to fill out that has, we're granting it, Nancy needs to sign it, the gentleman needs to sign it. Everything is filled out at the top of your signature, and their signature.
Lady that decides to secretary. Yeah. Think she's in? Yes, she will.
Have pheasants for everything. Civic cars, my God, he is he's got his permit today. Really, never been on before. My son did. My son did. My only son did. I got a priority t-shirt. I got a little flashlight.
For 4 years. I think
Kinds of dessert. At the end, as I've never been here before. Somebody said it's like I didn't remember reading that. Oh my God. Really good crowd there. People really don't give big bucks to that, so. Anyway, Dakota's folks were there, so we got a chance to catch up with them. We haven't seen them since their wedding. It's kind of sad. Just wanted to catch up with them. They were telling us how a tree fell on their house and wrecked how many rafters on the house. And then something about when the garage, I don't know if they were putting up a garage or something, but anyway, the walls of the garage caved in, and they just had a whole mess out there. Yeah, yes. He wasn't related to his knee surgery. He somehow contracted pneumonia, pretty serious pneumonia. To make sure he got his voice straight. You get those. Teresa, she's Mr. Happy go like yourself. She's fun. Teresa,
Oh.
I don't think so.
She was here for a long, is here too? I think, yeah. So did I. You like the woods? Yeah. I don't know.
Well, I know that one time we stepped up to the garage and dropped off a generator for our bill. And here was this line of chickens. She's walking safe file down the hill. I told Teresa,
They feed them.
that's kind of cool. I came from here, right? Thank you. Is that the 27?
I had a meal and of course they had speeches.
Speed of distance or speed of distance or 27. Yeah, exactly.
I thought it was, if it's not turned on, I apologize. The other guy's not turned on.
I'm sorry, we're renting this.
Hello? There we go. Thank you so much, guys. Teamwork. All right, we're back at the time.
Good job. All right, we're gonna start with the self-requirement 2 application, and the zoning administrator is gonna present a report on the application to the board.
All right, just prefacing, this one's a little longer than the Manatt one because there's a lot more information involved. And part of it is, as of Monday, I was tasked with making sure it was substantially compliant before making my recommendation. And I spent much of that time trying to research what substantially compliant is, and you're smiling because you know that I couldn't find an actual answer to that.
Easy question.
So, I've heard that Supreme Court justices were not able to define this, so, I will let you guys interpret substantially compliant on your own, in your own way. It's a variable term. It's subjective to the weight of the issues that you're reviewing and, the amount of issues you're reviewing. Not all topics are weighted equally. But since, my initial report of reviewing the application documents in July of 25, the only update that I've seen, prior to today was the FAA determination, no hazard. They have provided that in the binder. It was just they've applied for it. We do have confirmation that they've received that from the FAA for all 27 turbines they're applying for. I've contacted 99 people within the boundary and within the immediate edge of the boundary to notify them of this project. As last time there was a lot of feedback that people weren't aware of the project and I wanted to make sure no one was left out. 41 of those people were within the 1,000 feet, had property within 1,000 feet of a turbine location. 43 were slightly further than 1,000 feet. 9 were not significantly close to a setback distance, yet were within the boundary, and another 6 were along the border of the project. Those are the people that got letters notifying them of tonight. I also contacted the closest local airport, the Toledo Municipal Airport, which is owned by the City of Toledo. They have 2 trustees, and I emailed both of them, talked to both of them on the phone, just make sure they're aware that this was up. I had reviewed the airport tall structure ordinance that the county has. I did not see any significant issues with that ordinance as far as their conical measurements with how far away the furthest south turbines were, but I did let them know to notify me if they found any issues. I gave them maps of the furthest south turbines so that they knew how close it was going. I believe the revised version versus some of the earlier maps, they've moved it further north, so the furthest south of the boundary is along the Honda. So that does keep it further away from that airport, and I have not heard any complaints or concerns yet, unless I saw at least one of the gentlemen here tonight. He may speak up, I don't know. But I haven't heard any other complaints or concerns about the airport, so that should hopefully inform you for that area. I've also checked with our neighboring counties. As we know, we have a few turbines in neighboring counties. Poweshiek has 240, and he says the tallest is 492 feet. Marshall County shares our Vienna turbines, which are 489 feet after they're repowered, and then their Laurel project also has turbines that are under 500 feet as well. He said Alliance, I believe, also has shorter turbines in the 400-foot range. And both counties believe that they were keeping theirs shorter to avoid the FAA determinations and permitting process, which I heard that takes a while, so that makes sense. In July of 2025, I was first asked to look at this application, and I met with representatives of the development company, including Mr. Sean Roberts, who told me he was going to be here tonight, but yep, he's in the back there. And I presented the areas that I found that I thought were lacking in strict compliance with our 2010 WEX ordinance, along with the notations of where I made those observations within both their application and our ordinance. You have also received those notations so you could verify if my interpretation matched yours or if you had different interpretations. Let's see, I will note that the documents that are submitted are not the entire application. You do need to take into consideration the presentation you'll see tonight, any public comments from this hearing setting, and of course your time with the Q&As. I'm sure you have plenty of questions out of the application documents, and that should inform your decision as much as anything that you've read ahead of this, or including my recommendation. You've had plenty of time to try to come up with your own questions, and hopefully feel like you've had enough time to come to your own conclusions, so that my recommendation is not all that you're relying on. If we were going strictly off of the documents submitted, my opinion is that it is not substantially compliant. However, I do believe that great effort has gone with the development agreement that the supervisors have negotiated, the decommissioning the supervisors negotiated, and the road use agreement that was negotiated with the engineers department and the supervisors. And as well as Mr. Henderson, I believe, has also talked with the applicants to work out additional concerns that may have come up between the chairman and myself reviewing this application. So with all that information in mind, and not just relying on the submitted document from their application, I do recommend that you consider approving with conditions. I have a couple recommendations for conditions. One would be similar to Manatt's, having a sunset or an expiration clause where if no permitting has been submitted for building permits within a certain amount of time, that the conditional use permit then becomes null and void. I'm not saying like a quick amount of time, but I also understand if something happens and they're not able to build, we don't want to have a conditional use permit sitting out years in the future, coming back to older ordinances and older reviews and older studies. My suggestion is possibly 2.5 years. You may make your own suggestions on that. Other conditions that I would recommend would be duplicating what the development agreement has, just to fortify what they have negotiated between both Salt Creek and the supervisors, and to fortify the county's position and protect both the applicant and the county in those decisions that they've made. I believe that is the conclusion of my report and recommendations. Thank you.
Thank you. Okay, we'll move on to Salt Creek's presentation of 25 minutes, so we're going to.
I'll try to keep it brief. And I want to apologize to the public. I did have a presentation. Technology, I couldn't get it working. I did have printed copies that I gave to the board. So if they're following along with it, if they're looking down, that's what they're following along with. Can everybody hear me okay? Let me move this closer to here.
Can you all hear her?
Yes.
Okay, I'll move it a little bit closer. All right, my name is Kelly Orton, and I'm an attorney with the Brown & Law Firm, and I represent Salt Creek Wind 2 LLC. Thank you for your time this evening. I'm here to share with you details of the Salt Creek Wind 2 application and the related agreements that were entered into by Salt Creek Wind 2 and the Board of Supervisors a few weeks ago. The Salt Creek Wind 2 project has been in development in Tama County for several years. The project consists of a 100 megawatt wind energy generation facility in Tama County, north of Tama and Toledo. The project will include up to 27 wind turbines and related infrastructure, including access roads, meteorological stations, a project or collector substation, and collection lines to transport the electricity generated from the turbines to the project substation. The project will connect to the grid at the Toledo 161 kilovolt substation owned by ITC Midwest. Salt Creek Wind 2 LLC has obtained voluntary lease option or purchase option agreements for more than 9,700 acres in Tama County, but the actual land used for the project will be a fraction of this acreage. Many considerations went into selecting Tama County for this project and the project site specifically. The project developers evaluated many factors, including but not limited to the topography of the site, wind resources, available turbine technology, and Tama County setbacks when determining the proposed site layout, as well as turbine spacing and environmental, aviation, sound, shadow flicker, and subterranean constraints. Salt Creek Wind 2 submitted its application for a conditional use permit in December 2024 based on a wind ordinance in place at the time, originally passed in 2010. Notably, the application was submitted before the Board of Supervisors passed the resolution imposing a moratorium on wind energy conversion systems on January 6, 2025. The project was designed with the 2010 ordinance in mind. The project meets or exceeds each requirement in the ordinance, as I will discuss later. We are here today respectfully seeking the Board of Adjustment's approval of the Salt Creek Wind 2 project encompassing up to 27 turbines, as shown on the slide that would be up here, and various accessory structures. Before I begin discussing the contents of the application, I wanted to take a few minutes to discuss the two resolutions that were recently passed by the Board of Supervisors and the agreements that Salt Creek Wind 2 has entered into with the county. Resolution 9-22-2025C was passed by the Board of Supervisors on September 22nd, 2025. The resolution includes several provisions related to the project and the application for the conditional use permit. It also provides that the terms of the development agreement, which I will discuss in a minute, will supplement the application and should be considered by this board in making a final determination on the application. And importantly, for discussion here today, the Board of Supervisors resolved that Salt Creek Wind 2, through the application and the additional requirements made in the development agreement, has substantially met or exceeded the requirements of the ordinance. The resolution goes on to list several additional provisions relevant today to avoid any doubt regarding the application, including stating that as long as Salt Creek Wind 2 selects a final turbine model for the project and commencement of construction, and notifies the Board of Supervisors of the same at least 60 days prior to commencement of construction on the project, and said model is in compliance with all other provisions of the ordinance, the project will be in compliance with any provisions of the ordinance requiring the model be specified. Since all of the example models included in the application show that the project is in compliance with the ordinance, it can be assumed that the final turbine model chosen will be compliant with the ordinance. The wake effect study required pursuant to the ordinance is only required to take into account projects that were operational at the time of the application was submitted. Field wetland delineations do not need to be conducted until 30 days prior to commencement of construction. Any studies related to the project conducted within the past 6 years are deemed to still be valid and relevant. Denial of any permit or certificate due to the alleged staleness of the studies is unsupported by the ordinance and would be unreasonable. The engineer certificate required pursuant to the ordinance must be provided prior to commencement of construction, but does not need to be provided until the final turbine model is selected. This resolution was unanimously approved by the Board of Supervisors. Additionally, Resolution 9-22-2025D was also unanimously approved by the Board of Supervisors on September 22nd, 2025. This resolution confirms that the moratorium passed in January 2025 does not apply to the project or this application. That means the 2010 ordinance applies to this project. Given the interrelatedness of the conditional use permit application and the development agreement provisions, I want to discuss about that today as well. As noted in the resolution, the Board of Adjustment should consider the terms that Salt Creek Wind 2 has agreed to in the development agreement in evaluating the application. Salt Creek Wind 2 has agreed to abide by the requirements above and beyond what is required by the ordinance. Some of these requirements include, but are not limited to, agreeing to make a $1.3 million payment in addition to taxes to Tama County once the project is complete and certain conditions are met. Offering a good neighbor agreement to non-participating landowners within a half mile of any turbine that are not already subject to a similar agreement for another project. Agreeing to negotiate in good faith with any landowner who is currently a party to a good neighbor agreement and wishes to be released from said agreement, so long as the agreement is not needed for the development, construction, and or operation of the project. Complying with the road use agreement and decommissioning plan, both of which include more stringent requirements than those included in the ordinance. And agreeing that Salt Creek Wind 2 and its successors will not fund, develop, or plan any future wind projects in Tama County. In addition to these requirements, Salt Creek Wind 2 has agreed to conditions that are more stringent than the ordinance. For example, for residences, the ordinance requires a setback of 2 times the turbine height, or 1,000 feet. Salt Creek Wind 2 has agreed to 1,500 feet from non-participating residences. The ordinance has a 60 dBA limit from the wind turbines at residences. Salt Creek Wind 2 has agreed to a 50 dBA limit on non-participating residences. The ordinance requires that no artificial lighting be used except as required by the FAA or other authorities. Salt Creek Wind 2 has agreed to submit all necessary requests for the use of ADLS and install if approved. The ordinance does not have a shadow flicker requirement. Salt Creek Wind 2 has agreed to an annual limit of 30 hours of shadow flicker at nearby residences. As part of the development agreement, Salt Creek Wind 2 agreed to enter into the road use agreement approved by the Board of Supervisors in September of this year. This road use agreement imposes many road and drainage system related requirements on Salt Creek Wind 2 that are not required under the current ordinance. Key provisions of the road use agreement include requiring a pre-construction survey prior to hauling operations, placing responsibility for maintaining and repairing the roads with Salt Creek Wind 2, requiring Salt Creek Wind 2 to fix any damage to drainage structures as soon as practicable, requiring reasonable precautions to prevent fugitive deaths, providing a certificate of liability insurance, and providing financial security to cover 130% of the estimated restoration costs. Salt Creek Wind 2 has also agreed to enter into the decommissioning plan approved by the Board of Supervisors in September of this year. This plan sets forth Salt Creek Wind 2's responsibilities for decommissioning, including removing the turbines, collection lines, and foundations to 48 inches below grade unless otherwise agreed by the landowner, and removing access roads unless otherwise agreed by the landowner. The land will be returned to a condition reasonably comparable to the surrounding property. Decommissioning will also be subject to the same standards as the road use agreement, so the project owner will be responsible for all costs and repairs associated with hauling roads or drainage systems. Salt Creek Wind 2 must provide a cost estimate for decommissioning and update that every 3 years. Then Salt Creek Wind 2 must provide financial assurance to the county equal to 150% of that estimate. This is separate from the road use agreement financial security, so there will be 2. This project will be economically beneficial to the county. Assuming the conditions are met, Salt Creek Wind 2 will make a $1.3 million payment to the county once the project is completed. The project is also expected to generate more than $32 million in taxes over the life of the project. A significant fraction of that will go to the school district. It will also create jobs for construction and support technician jobs during operation. Now that I've discussed the additional protections and benefits that this project will bring to the county as a result of the development agreement, I'd like to walk through the ordinance and clarify how each requirement has been met. Section 2003.2A, color and finish. This requirement has been met. The project will use materials, color, and texture that blend with the natural setting and the existing environment. The turbines will remain in their factory finished color, a non-reflective and unobtrusive shade of white. Section 2003.2B, tower configuration. This requirement has been met. The project will use self-supporting tubular steel towers. Section 2003.2C, lighting. This requirement has been met. The project will be lighted in accordance with the requirements established by the FAA. The development agreement further requires that ADLS be applied for and, if approved, installed on the project after construction. This is above and beyond what is required by the ordinance. Section 2003.2D, signage. This requirement has been met. All sign requirements will be followed. The turbines may show the manufacturer's or owner's name or logo on the generator compartment, but will not include any advertisements. Section 2003.2E, feeder lines. This requirement has been met. All collection lines and communication lines for the project will be buried to a depth of 40 inches or greater. Section 2003.2F, waste disposal. This requirement has been met. A spill prevention, control, and countermeasure plan will be in place prior to commencement of construction that will meet or exceed the Tama County Health Department requirements and all state and federal standards. Section 2000.32G, minimum ground clearance. This requirement has been met. Salt Creek Wind 2 has not finalized its model selection for the project at this time. The application lists the turbine models that may be used. All models included in the application and in Appendix B to the development agreement have a ground clearance of at least 75 feet. Consistent with the recent district court opinion for Phase 1 and recent decisions from the Iowa Supreme Court, The model ultimately selected will be in compliance with the ordinance. Neither require that a specific model be selected at the time of the filing of the application. Under the development agreement, Salt Creek Wind 2 must select a turbine model and notify the Board of Supervisors at least 60 days prior to commencement of construction on the project. If the model is in compliance with all other portions of the ordinance, which it will be, the project is in compliance with any provisions of the ordinance requiring the model to be specified. Section 2003.2H, signal interference. This requirement has been met. Salt Creek Wind 2 has undertaken broadcast communication studies as provided in appendices Q, R, S, T, U, Y, and Z of the application to evaluate potential impacts on radio, off-air broadcast TV, communication towers, phones, microwave paths, and emergency services. The turbines have been cited to minimize interference with electromagnetic communications based on these studies. A summary of each of these studies is included in the application. Section 2003.2I FAA. This requirement has been met. A DNH was obtained for each turbine locations in May of 2025. These were provided to the Board of Supervisors and to Laura in September. Salt Creek Wind 2 will construct the project in compliance with each DNH. As previously mentioned, the development agreement further requires the ADLS will be applied for and, if approved, installed on the project after construction, which is a requirement that exceeds the ordinance. Section 2003.2J, electrical codes and standards. This requirement has been met. The project has been designed to ensure it is in compliance with all applicable provisions of the National Electric Safety Code, the American National Standards Institute, the Institute of Electrical and Electronics Engineers, and the National Electrical Manufacturers Association. Section 2003.2K, setbacks. This requirement has been met. All turbines are located at least 1,246.6 feet from the nearest residence, school, hospital, church, and public library. 1,246.6 feet equals 2 times the height of the tallest turbine listed in the application. In the development agreement, Salt Creek Wind 2 further agreed to site turbines no closer than 1,500 feet from non-participating residences. This exceeds the requirements of the ordinance. No turbine will overhang a property that doesn't have an existing easement. The project was designed so that all turbines are located at least 270 feet from the nearest non-participating property line to ensure that no turbine will overhang onto a neighboring non-participating property. All turbines are located at least 703.78 feet from the nearest public right-of-way, railroad, power line, non-occupied structure, and above-ground public electric power line or telephone line. 703.78 feet is equal to 1.1 times the height of the tallest turbine listed in the application. Section 2003.2L, noise. This requirement has been met. Salt Creek Wind 2 has agreed in the development agreement to a noise limit of 50 dBA for any non-participating residence. This is more stringent than the 60 dBA limit in the ordinance. Appendix M contains the noise study commissioned by the Salt Creek Wind 2. The noise study is a conservative estimate using maximum noise generating conditions and studying 31 turbines rather than the 27 included in the application. The noise study shows that the noise levels from the turbines will be below 50 dBA at all participating and non-participating dwellings. In the unlikely event that the project exceeds 50 dBA, the development agreement sets forth provisions which would allow for this to be resolved in a timely manner. Section 2003.2M, safety. This requirement has been met. All collection lines and communication lines for the project will be buried to a depth of 40 inches or greater. All proposed turbine models are designed so they are not climbable for the first 15 feet above ground level. All access doors will be locked except when access by authorized personnel is required. The locked base of each turbine will have a high voltage warning sign. Any other appropriate warning signs will be installed. Consistent with the development agreement, the certification from a qualified engineer will be provided at least 60 days prior to commencement of construction, once final turbine model is selected. Guide towers are not expected to be part of the project at this time. Section 2003.2N, discontinuation and decommissioning. We have broken this into 3 sub-requirements for ease of review. Requirement 1, all CWEX and accessory facilities shall be removed 4 feet below ground level within 180 days of the discontinuation of use. This requirement has been met. The updated decommissioning plan attached to the development agreement provides that upon decommissioning, all facilities related to the turbine will be removed to a depth of 4 feet. Requirement 2, each CWEX shall have a decommissioning plan outlining the anticipated means and costs of removing CWEX at the end of their serviceable life or upon becoming a discontinued use. This requirement has been met. Via the development agreement, Salt Creek Wind 2 has agreed to enter into a decommissioning plan providing more strict requirements than the decommissioning plan included in the application. The new decommissioning plan includes additional protections for the county that are not required in the ordinance. Requirement 3, the cost estimates shall be made by a professional engineer licensed in the state of Iowa. The plan shall also identify the financial resources available to pay for the decommissioning and removal of the CWEX and accessory facilities. This requirement has been met. The development agreement requires Salt Creek Wind 2 to provide an updated estimated cost of decommissioning the project every 3 years, beginning 3 years after commencement of commercial operation. This exceeds the requirements of the ordinance. The results of the estimated costs must be provided to the Board of Supervisors and County, and the bond must be adjusted accordingly, ensuring the county is protected as the project progresses into the future. Section 2003.201 roads. This requirement has been met. Salt Creek Wind 2 has entered into a road use agreement which requires Salt Creek Wind 2 to identify all roads to be used for transporting project components for construction, operation, and maintenance of the project. The road use agreement exceeds the requirements of the ordinance. Salt Creek Wind 2 will also obtain all required ministerial permits for the project as required for construction. Section 2003.202, existing road conditions. This requirement has been met. Salt Creek Wind 2 has entered into a road use agreement which requires Salt Creek Wind 2 to conduct a pre-construction survey and requires them to be responsible for ongoing road maintenance and dust control measures as identified in the road use agreement. The road use agreement exceeds the requirements of the ordinance. Section 2003.203, drainage system. This requirement has been met. The road use agreement requires that all drainage structures be regularly inspected by the project developer and its contractors. Any failure shall be immediately reported to the county engineer and repaired as soon as practicable. Section 2003.2P, required financial security. This requirement has been met. The road use agreement requires that financial security to restore the roads and bridges in the amount of 130% of the estimated cost of Salt Creek Wind 2's restoration obligations be posted prior to commencing hauling operations. Section 2003.2Q, submittal requirements. This requirement has been met. I'll briefly go through each requirement now. 1 and 2, the names of the project application and the name of the project owner is Salt Creek Wind 2 LLC. 3, the legal description and address of the project. The legal description of each wind turbine is located on page 7 of the application and in Appendix C. 4, a description of the project including number, type, nameplate generating capacity, tower height, rotor diameter, and total height of all wind turbines and means of interconnecting with the electrical grid. As previously mentioned, Salt Creek Wind 2 is a proposed 100 megawatt wind energy generation facility. The project will consist of up to 27 wind turbines, and the final model will be selected at least 60 days prior to commencing construction, as required in the development agreement. From the project substation, the project will connect to the grid via ITC Midwest Toledo substation. The tower height, rotor diameter, and total height of each potential model is listed on the turbine candidate table in the application and in Appendix B of the development agreement. Salt Creek Wind 2 anticipates that whichever turbine model is selected will not exceed 195 meters or 639.8 feet. Consistent with the recent district court opinion for Phase 1 and recent decisions from the Iowa Supreme Court, the model ultimately selected will be in compliance with the ordinance. 5. Site layout, including the location of property lines, wind turbines, electrical wires, interconnection points with the electrical grid, and all related accessory structures. The site layout shall include distances and be drawn to scale. All of this information is available in Appendix B to the application. 6. Engineer certifications as required in these supplemental standards. Consistent with the development agreement, the certification from a qualified engineer will be provided at least 60 days prior to commencement of construction once the final turbine model is selected. 7. Documentation of land ownership or legal control of the property. Legal control is shown in Appendix D to the application. Salt Creek Wind 2 understands that it cannot build on any land for which it does not have an easement. 8. The latitude and longitude of individual wind turbines. The latitude and longitude of each turbine is shown on the wind turbine legal description table in the application. It's also provided in Appendix A to the development agreement. 9. A USGS topographical map or map with similar data of the property and surrounding area, including any other CWEX within 10 rotor diameters of the proposed CWEX. Appendix B to the application is a and as of the date of the application, no existing wind turbines were in operation within 10 rotor diameters of the project. 10. Existing resources inventory. As part of the development process, Salt Creek Wind 2 completed several studies surrounding existing resources. The application includes a summary of the Phase 1 environmental site assessment, the wetland delineation and stream identification report, the site characterization report, EV&U surveys, raptor nest surveys, and bat habitat assessment and acoustic detector locations overview, all of which are included as appendices to the application. Additionally, Salt Creek Wind 2 completed a Phase 1A cultural resources study, a summary of which is included in the application. Because certain locational information related to archaeological resources are confidential under Iowa law, the report was not provided as part of the application. 11. Acoustical analysis. A sound report was included as Appendix N to the application. As discussed earlier, sound levels at nearby residences were modeled below 50 dBA. 12. FAA permit application. FAA permit applications were included as Appendix N to the application. The permits received in May of this year were provided to you previously. 13. Location of all known communications towers/facilities within 2 miles of the proposed CWEX. A table showing the location of all communication facilities within 2 miles of a turbine is included in the application. Additionally, as mentioned earlier, Salt Creek Wind 2 conducted several studies to evaluate the impact of the project on communication facilities and has cited the project to minimize any potential impact. 14. Decommissioning plan. While a decommissioning plan was submitted with the application, under the development agreement, Salt Creek Wind 2 has entered into an updated decommissioning plan containing more stringent requirements than those requirements under the ordinance, as discussed previously. 15. Description of potential impacts on nearby all CWEX and non-CWEX and wind resources on adjacent properties. A wake study was conducted covering the 4 existing and operational wind projects within 18 kilometers of the project at the time of the application. The model wake impact on nearby wind farms was minimal. The study was included as Appendix P to the application. As stated in the development agreement, the wake effect study required pursuant to the ordinance is only required to take into account projects that were constructed and operational at the time of the application was submitted. But it is important to note that no turbine will be any more than 5 rotor diameters from any turbine from Phase 1. 16. Identification of significant migratory patterns and nesting areas for birds within 2 miles. Salt Creek Wind 2 conducted AV&U surveys and an eagle and raptor nest survey, as well as a site characterization report to identify any significant migratory patterns and nesting areas for birds within 2 miles. The AV&U survey reported birds flying above 500 feet, so according to our environmental consultant, requiring an updated survey with a higher rotor swept zone would not provide a meaningful distance. The results were provided with the application as appendices J, K, and X. That is everything. All of the conditions and requirements. Whew. Salt Creek Wind 2 has met every one of them and has provided evidence of that. The development agreement includes even more restrictions that are included in the ordinance as described above and provides additional safeguards and protections for the county, some of which don't exist in the current ordinance. We ask that the Board of Adjustment grant the conditional use permit. Thank you for your time. Thank you for bearing with
Okay, now we'll move into the public comment period, so if, I believe Laura had a sign-up sheet,
We didn't have a lot of names on it.
3 minutes each, and you come up to the mic and the podium. She wants this.
We'll start with the names on here. If anybody decides they'd like to add later, you're welcome to come sign up at the end. And then we have a handful of people that have emailed. I have copies for you. I can read those aloud when we get to that. Would you like me to start with those or start with people
In the room. probably.
Okay. Frank Albertson. If you want the microphone, it is still on. If you can talk super loud, you can talk from here.
Where do you want me, over there?
If that works for you.
Pardon my nervousness, I'm a little unsteady because of health reasons. My only comment is that my son and I buy land to farm. We try to do the best job we can. We don't buy it for someone else to tell us how to do it, how to use it, what restrictions or wishes they put on them. And that's my only concern. When they put a pipeline through a few years ago, they contacted all landowners and renters personally, told us what they plan to do, how they plan to handle fences, tile lines and everything. Was very good to work with. No one has contacted me personally on this project. My concerns are, as a cattleman, what are they gonna do to my fences when they go through? Do they even have an up-to-date list of ownership? I've tried to contact the office here in town, it's never open. My concern is that when they go through, even if it's 40 inches, they restore my tile lines so they're in working condition. Don't go up and over, try to go under and fill them full of dirt. When they go through my fences, fix them. And what do? Where they plan to go through where I have livestock and pasture. Are they gonna take care of those cattle? Or is that my responsibility? And that bothers me. Where they go through, I've got some areas where there's native springs. Will those lines change that water flow that I use for cattle water year round? There's other things I could comment on, but I just, when you give up a right of way, it's forever. I bought that land to farm, that's what I'd like to do with it my way. That's really all I have to say. If you use it, put it back the way it was. You know, if I have problems later, will you come in and fix them? The pipeline was very good. Come back in and fix any damaged tile lines or changes in water flow. After they talked to me, they moved the pipeline a quarter mile, which was a big project for them. Nobody's contacted me. Thank you.
All right, the next person is Al Shafar.
Yeah, my name is Al Shafar and I live in Reinig. And I'm here tonight because this is a very complicated project that has many facets to it. And what I'm here tonight is to ask you not to vote one way or the other, but to consider that you 5 people represent the citizens of Tama County, and that when you make your decision, it should be what is for the good of the people of Tama County. That's the reason you're here, is to represent Tama County. So that's my ask, is that you do your research and make your best decision for the county.
Patrick Corman.
I'm gonna pass for.
Pass?
Yep.
Okay. Bob Lacone. Sorry, you signed it Robert, would you rather?
Oh, that's fine, that's fine.
Good evening, everyone. This evening, the Board of Adjustment will be discussing whether or not to issue conditional use permits for Salt Creek Phase 2. As many are aware, the wind farm project has been an issue for quite some time. Many questions have been asked and answered over and over again. Lots of misinformation has been put out to the public, and the TCAT group has attempted to put a stop to the wind farms. The courts have ruled against the opposition, yet this small, very loud group of people who totally oppose any industrial wind or solar projects in this county still persist. I'm going to make myself very clear on this matter. I was the zoning administrator who approved and issued the zoning certificates for Salt Creek Phase 1. I asked many questions and consulted with council many times prior to signing the certificates, 10 days, not 7, after they had been received. I most certainly did not rush or ram the certificates through, as I have been accused of doing by Supervisor Kirk Hilmer. Hilmer also made comments in yesterday morning's meeting to the effect that the previous zoning administrator did not follow code. There was no legal reason to deny the certificates, and that was confirmed by legal counsel prior to me approving and signing the certificates. I certainly would not have approved or issued those certificates if there had been a legal reason not to. Salt Creek Phase 2 applied for conditional use permits in December of 2024, prior to the moratorium being put into place in January of 2025. The Board of Adjustment was advised that they needed to meet concerning the conditional use permits. However, they could not meet until litigation matters were settled concerning the Phase 1 certificates. Phase 2 is much like Phase 1. I informed Supervisor Heather Knevel that she was going to spend a lot of taxpayer money to try and stop a legally permitted project, and in the end, the county would be paying out millions from litigation, and the wind turbines would still go up. This county was very fortunate that a settlement agreement was reached with Phase 1. We are all aware that current members of the Board of Adjustment have strong opinion against industrial wind energy projects. That doesn't necessarily mean that you have closed minds. I think that you can be open and clearly see the situation here and do your job properly. The right thing to do in this case, for example, is to grant the conditional use permits with the conditions of linking up the make and model of the units prior to construction, or conditional use permits could be revoked. Supervisor Heather Knevel and Zoning Administrator Laura Wilson are founding members of the TCAT group and have been very vocal against wind projects. All of this really puts Tama County in a very bad position if the board chooses to vote against a project that meets requirements for conditional use permits to be issued. This is what will happen if this is voted down. The settlement agreement goes away.
Come on.
You gotta finish 2 paragraphs, all right?
2 paragraphs? That's up to you.
2 paragraphs.
Okay, thank you. The settlement agreement goes away. The county loses $1.3 million right off the bat. Thousands of dollars for other things such as food pantry and the county fire departments. It all goes away. Tama County gets sued for millions and they will lose. The wind farm still gets built. The small anti-group gains nothing but costs the county millions. I served as a law enforcement officer for over 37 years before retiring. There were several laws and ordinances that I and other officers may not have agreed with. However, we had to enforce them to make our decisions based on the code. Settlement agreement has been made for the Board of Adjustment, and they're asked to make a decision based on the facts and information given. Whatever your final decision may be, you need to be able to explain to the public why you voted the way you did. Thank you for your time.
Would anyone else in the room like to comment?
Frank's cane. First off, Laura is not a founding member. Clarify. So, if you approve this, I urge you to do it only with conditions. And, you know, I've personally sold over 4,000 head of cattle in my lifetime, so that doesn't make me an expert. No matter what, I'm still learning every day for 4,000 turbines. My concerns are that we are not working with local people, but salesmen from Florida or even farther away. So what I've seen and read recently is that now there are going to be 30 to 50 years of no crops and much land taken out of production. So that's been a very misleading piece of information that we've just learned in the last few months. Salt Creek Phase 2 is owned by Salt Creek, not NextEra. That has been misleading and very confusing. A lot of this stuff came in under COVID, so there are so many things we didn't know. After going to most of the meetings, I can tell you that there are sure a lot of half-truths, and some of them were just now said tonight, and also in the 2-page September Salt Creek article that was basically an advertisement by the Salt Creek project manager. I've had a lot to say over the last 4 years, but if anybody that is not in currently Phase 2 footprint mapped out land use, if your land is not in that phase, I urge you to have a lot of guts and courage, and even if maybe you are in that, get out and say so and say you want out. I don't know who's gonna be accountable for all the complaints, problems, decommissioning sites, because we don't have any from all the storms that we have every 5 years. I don't know when all these men leave, in a year or two. I don't know who's gonna be accountable for that. We need to be respectful of height and setbacks, even though other counties are under 500 feet. We have been told in the last month that these could be as tall as nearly 700 feet. And that will be over by Tama County Lake. This project has been in the works for many years, but we've only known about it since July. And we still have a lot of questions about property taxes, numerous questions about property taxes, and who's going to supervise this project 5 years from now, or even 4 years from now. And you know, these maps only went out this fall. So even though I live a mile from these turbines, we didn't know anything about it. It's an amazing thing. We didn't know anything about it. Can I live with them? Yeah. Am I going to have a nervous breakdown because of them? No. Am I going to be able to shut my eyes and go to sleep at night? Yes. But it's an amazing thing that we're working with companies that have not been transparent and have not told us any truth. It's amazing. Thank you.
Is there anyone else in the room that would like to comment tonight? Yes, Maureen?
And I love the presentation tonight. It sounded like all the requirements have been met. Heard that over and over. Requirement, a number, have been met. I appreciate that you keep an open mind while you're deciding. I appreciate that the recommendation that Laura gave you, and I hope you can follow through. Thank you.
Anybody else change your mind and want to comment tonight? Come on up.
Good evening, Mark Dolan. I'm here as a Tama County resident, not as a supervisor. I found it interesting that you couldn't find the definition of what substantial means, because it was cited 10 times by Judge Cox in his ruling on this temporary injunction hearing. Use it 10 times because that's the standard. When you get arrested, the standard to convict you is beyond the reasonable shadow of a doubt. When you're in civil court, it's a preponderance of evidence, meaning just a little bit more than likely to be true than not. Substantial compliance is a standard that is applied to this project, applied by Judge Cox. That terminology comes from the vested rights doctrine, and so that's really the question that was in our minds when we took over. Do they have vested rights? That's what they wanted to know. That's why we went to court. The judge found that they were, that they did have on the first project, Salt Creek 1. Transferring that to Salt Creek 2, the argument that we used is the same one that has been posed and asked for a condition on out of the 2010 ordinance. It says this, the judge's ruling, first of all, to be granted the temporary injunction, a lot of people have said that's just nothing. I mean, that's like nothing. Okay, well, we couldn't get one to stop the project. We couldn't even get them to hear our arguments to stop the project, but they got them to hear it on the first one. And they ordered the temporary injunction. Because one of the standards that they have to meet is that the project would likely be successful all the way through to the Supreme Court. Judge Cox says this, the testimony at the hearing is that while they may be different, excuse me, let me back up. The Tama County argued at the hearing that the wind turbines being erected are different models to the ones mentioned in the application. Does that sound familiar? That's what we're talking about here. The testimony at the hearing is that while they may be different models, they're substantially the same as the models listed in the application. The models actually being used are slightly shorter than the models listed in the application. Updated studies have been completed, such as noise studies, no evidence was presented at the time of the hearing that the new turbine models are different in any significant way to the models which were mentioned in the application. There's also testimony that some of the wires and the lines need to be moved from one location to another for various reasons. There's no explanation by the defendant on why the new plan is significantly different enough to make it outside the scope of the cut. The application clearly anticipated electrical wires being buried underground, connect the turbines to a substation, but the exact location would need to be adjusted upon factors determined at a later date. Defendants failed to establish the new lines and their new positions changed. Essentially, as it comes down to say that there's no significant difference and that the models that were submitted were substantially in compliance, and would be, again, in the same part.
Richard?
I think most of you know me, Richard Art from Geyser. I want to clarify a mistruth that Bob Boku made. TCAP only has 4 members, but well over 1,000 supporters in Tama County. Nobody on the Board of Adjustment is a member of TCAP. All I want to say to you tonight is that I'm not going to tell you how to vote, but make sure your decision is by the law, and make sure that Salt Creek Wind 2 has dotted their I's and crossed their T's before you allow them to build. Thank you.
Would anyone else like to speak? Sorry, I'm not sure if I learned your name.
Jamie Coster, Toledo resident. Cam Coster and I are T1 for turbine on our farm. I know that as a community member and many of you who disagree with turbines, you say that it shouldn't be about the money, but it should be about the money. Our community is failing when it comes to money. Our school system is failing. I have done some research, and if our county fights this, we can go bankrupt. That means a reduction in our police services, our fire services. It's already low. We're already having a hard time hiring. We are losing teachers. That means that we're losing children to stay in this community. Our community will die. As a teacher for 20 plus years, being in the school systems, curriculum is expensive. This money can help our children. So please, vote for this to go through. Thank you.
Anyone else? Yes.
Dwayne Albertson, part of the Windmill 2 project, farm within that organization. Alluding to the young lady that just spoke before me, if you continue to look at the families and the population decline, the number of individuals that are born as in rural communities continues to decline. You have young individuals that no longer are having multiple kids that are going to sustain these school districts. We have the same issue in multiple rural communities, and spending money on the school districts and spending money on new buildings and so forth that are lavish is unnecessary in my opinion. We can get by with minimal maintenance and have a successful and important education for our youth going forward. We didn't have lavish when I went through school. I graduated from South may not be the smartest individual in the world, but I've seen a few things in my lifetime. I've been very privileged. And as farmers and landowners going forward, we are the individuals who take the brunt of the taxes for the communities and helping individuals. What I understand, we want to help the community, and I'm all for helping others. I'm a member of the church. I help my neighbors. No matter what, I'll give the shirt off my back to help others. But what are we doing to help the farmers, the individuals, the landowners that are affected by this project? That's my question. What are they getting if they're not getting money from the mills themselves? That's the only question I have. I appreciate your time. Thank you.
Anyone else? No one online has mentioned that they want to comment after I ask. Last call for anyone else in the room? Okay, I do have a handful of comments that were emailed to me. The first was from Mr. Shafar. He already spoke and said I didn't have to reread this. The second is from, I hope I don't mispronounce it, Corinne Jensen. She says, please vote to accept the negotiated terms of the Salt Creek Wind 2 wind project. Sincerely, Corinne Jensen. This one is Linda Reardon Lowry. Thank you for your ongoing service to Tama County. As a taxpayer, I urge you to support the negotiated agreement for the windmill project. Responsible management of public funds is important to me. Please consider the financial impact of additional legal expenses. The next is Tom Waller. Hoping at Tuesday meeting that you folks think about doing the right thing and admit that the judge has given the verdict and the fight should stop and not cost the county taxpayers any more in frivolous lawsuits and avoid any more destruction to our county revenue stream. As a farmer, we cannot keep pace with our property taxes and facing an imminent farm crisis coming on the horizon. We need to be considering the extreme loss of tax value in rapidly falling farmland values. Do not let these petty excuses and false propaganda by your anti-views keep our county from a positive income flow. Set aside your TCAP views and personal agendas for the betterment of our county taxpayers and residents. Thank you, Thomas Waller. And just another note, not that it matters, we pay over $50,000 in our county taxes per year, so hopefully you folks will listen to some common sense and vote for the taxpayers' best interests. Also, you're violating property owners' rights in pursuing the ability to make income from this personal property that may be illegal to deny his right to do so. My opinion to the Tama County BOA. The last comment that I had emailed is from Steve Aldrich. I feel it's not in the best interest of Tama County to continue to fight. We simply cannot afford the cost of attorneys. The vast majority of owners in the Phase 2 project are in favor of the project. The county is in dire need of money, and the project will add thousands of dollars each year to the county and the farmers in the project. People who are resisting need to use their own money to continue their effort. Thank you, Steve Aldrich. I believe that's everybody's comments, unless somebody else in the room changed their minds.
And Ms. Orton had asked for a 5-minute break for her to collect her thoughts, and then she'll have rebuttal to any comments made. So we'll take a 5-minute break. Maybe by the end.
He's a rebel. He's a rebel.
Yeah, I suppose that probably happened about 2 minutes. We went and we took out our CBs here.
Where's he at? Where's Carl at? That land that Frank had?
So you should go for well, it hasn't been asked yet since we have to have them to bring in people. Really?
Who would his neighbors be?
I don't see them. There's a couple, that's it. But this is
between 53 and 21.
huh? This isn't his video. I know. He's tired. He needs milk.
And his wife from where?
I said it's gonna be quick.
What Joe have for kids? He does.
He doesn't care. He is a girl. He says first thing.
Hey, I have. You should have seen it when I was 16. I think it would have passed me. She could.
That's what I suggested. Gives you more public comment time. Yeah, but you have to say this one. There's people here. There's two of them right up there. And then he's a teacher. Right now, he's a professor. He's been teaching for 100 years. Forever. Until they got sick.
They said they were doing advertising on that. I see his view, we got a bit of earth on, you know. I mean, not in this area, you know, but I've seen it.
I don't know. People never want to speak. Huh?
So we're gonna get started here. I think I can yell loud enough. We're gonna give Salt Creek 2's attorney, Kelly, 5 minutes to, address, any rebuttals from public.
Okay, I just wanted to start off, I think there were a lot of questions in the comment here in the public about what APLS is, when I was referring to that. It's an aircraft lighting detection system, and what that does is a turbine's natural instinct requires to have the lights flickering, right? The APLS system will detect an aircraft. If there's an aircraft not nearby, it will turn the lights off. So you won't have to see the flickering, and if the aircraft comes within a certain vicinity, the lights will then turn on to alert the aircraft if the turbines are there. So that is what we will be applying for, is the system that will allow the turbines to turn the lights off. So that's what that is. We also wanted to address the fact that leases or easements are already in place, and I understand that we cannot install a facility, on a land without having an easement. So we're not gonna build anything or do anything on any land for which we do not already have an easement, or we don't obtain an easement at a later date. And finally, this project is going to be an ongoing project. We're not done tonight, we're not done when it's constructed, it's going to continue to be operational. The owner of the project is going to continue to have obligations ongoing throughout the life of the project. It's very valuable, nobody's gonna walk away from a project like this. Salt Creek Wind 2 is gonna be in the community for 30 to 50 years, and they wanna work with the community and be a good neighbor, and they understand that there's going to be ongoing obligations. They're not just gonna walk away and leave the landowners or the county with things such as decommissioning or road requirements, and part of that is why we have those financial securities that will be provided. That's all I have to address.
So now it is the time for the Board of Adjustment to ask questions. And will it be all to you, Ms. Orton, or will it be to Mr. Roberts?
I'm going to ask Mr. Roberts to come up, and
Okay.
we will tag team.
Okay. And I don't need to be the first one. I mean, any of the other 4 board members here are able to speak at any time with any questions you have, so I'll let someone else speak if you'd like to first.
So when you just said the light will come on and off as an airplane comes through, how far is the airplane out before it comes through?
I don't know the exact number, but it's just miles. So the lights will stay off the whole time until there's an aircraft detected. And then at that point, the lights will come on so you know where the wind turbines are.
And this system is approved and regulated by the FAA, so it's going to be in a distance that is safe for airplanes. They're not gonna have that be a closer distance than what would be safe for pilots to be able to see it and react accordingly.
And this is a brand new technology. The FAA has just very recently approved this technology. So when we applied for this project years ago for the FAA, that technology was not available at the time. That's the reason with negotiations with the county, we said we would apply for it after the construction.
One of my main concerns is that you have not identified, it's not the model, I don't care if it's Vestas, GE, Siemens, it's the height. And reading through all the studies, the avian use study, and we're not specifically talking bald eagles, because I know they fly very, very high. But I learned something about SGCN, Species of Greatest Conservation Need. And there are 2 Iowa state endangered species, one being the northern harrier and one being the red-shouldered hawk. And when Stantec, the firm that did your avian survey, they said, we don't know what turbine is going to be installed. So they used one that was 155 meters tall, and I had to have my meter value here, but that is like 508.5. We'll just say 500. And so then they had tables for all the different game birds, shorebirds, raptors, water birds, I mean small game, and they identified how many of them for this rotor swept zone that was identified by Stantec for this model. So they went from 100, and again, they're talking meters, I'm transferring it to feet, 144 feet from ground to the tip of the blade, and then it would go up to 508.5 feet. And so then they identified how many birds they registered that were flying below that, through the middle, and above that. And the survey, the large bird use survey, ended up with going underneath the rotor swept zone was 21.8% of the birds. Within the blade, the rotor swept zone, it was 23.1, and over the top, above 508.5 feet was 54.3. So more than half of them were going over the 508.5. So in my mind, and I looked at the, table of turbines that you had attached to the,
Was that using more hot or something?
well, no, they had attached a turbine model appendix B to the development agreement. And it actually had 12 models listed here where you had 8 in the application. And so you've added one more that's shorter. And so I would like, this is a big ask, but I would like to leave here tonight knowing that your turbines will go no higher than X. And, you know, I asked Mr. Henderson's assistance, and he's, you know, kind of identified 520 feet. And in this turbine model table of 12 models, you have a GE and then an SGRE manufacturer. One is 500 feet, 0.4, and one is 511.8. Because I am just concerned, you know, there were 660 total birds that flew above that 508 foot. And that ended up to be, you know, 54%. Water birds, it was almost exclusively, you know, geese and turkey vultures, which not everybody likes turkey vultures, but I mean, those 2 species of the Iowa state endangered, you know, there was only one that was identified to go above it. The others were either below it or within it. So those 2 are not my main concern. It really was like the water birds. So, you know, the supervisors have said what a great negotiator you have gotten to be over these last weeks. So I was just wondering, you know, and Mr. Henderson had put together something that kind of said, tonight we would pre-approve with X number of fees. And then if later on you find that you have to do longer blades, then, you know, you would have Stantec come back and give us further information. But Ms. Orton on October 2nd, in her letter to Laura, answering some of Laura's concerns, she just said Stantec Consulting Services affirms that the studies included the entire project area, explains the methodologies used, and clarifies that each of the studies are still accurate and applicable. So I'm thinking, if they said on October 2nd that they're still accurate and applicable, I don't know how they can come back later and say, oh, well, really, no, you're not gonna lose any more birds by having a 640-foot tall turbine.
I talked to them today, and if we do go for what we're writing up today, is that we will do it won't be a full-blown study again, because we have so much data, but they'll do a report based on the larger rotor. And the reason that we've been looking at larger rotors is the county actually has asked us to put in fewer turbines. And so to do that, that means we have to go with bigger turbines. And so right now, we are asking for 27 CUPs, but it might only need to be 24, could be only 20, depends on what size turbines we use. And so part of the negotiation was that the county wanted much fewer, as few turbines as we could put in.
That was my question. What's the correlation between rotor size and height? Can you have a bigger rotor and still maintain a shorter turbine?
Theoretically, yes, but you gotta go to a minimum ground clearance. You don't want the rotor that much closer to the ground.
Okay. And
what you end up with is on a wind turbine, the bigger the rotor is, you got wind shear going across there. And so you think of it like a big frisbee. And so lower you get that blade to the ground, you like a stream, you see the water at the bottom of the clear stream going slower than the top. Because of the drag. And so the same thing we have on the ground is we have trees, buildings, stuff that will drag the wind down lower you get to it. So that's the reason we try to keep them up high as we can, so we have an even shear across the bottom of the top of that rotor. It just, it's less wear and tear on the turbine.
And Laura had investigated Powashik County, to the south. They have a total of 240 turbines in their county, all under 500 feet. Marshall County, their current heights are all under 500 foot threshold. Vienna, western Tama County are 489. Salt Creek 1 is 500.35. So I'm apprehensive about having Tama County be the first county in central Iowa with these big turbines. And I know that AI is frowned upon, but it seems like we're all being pushed into using AI. And I just, typed in, is there a legal basis for height conditions? And it just said the practice of using CUPs, conditional use permits, for wind energy systems is legally sound, and courts generally uphold a local government's authority to grant such permits under specified conditions. When reviewing a CUP application, a planning commission or board of adjustment determines whether the project meets all of the conditions set forth in the local ordinance. This process is discretionary, allowing the board to impose conditions that address potential negative impacts, such as limiting the height to mitigate visual impact. So I am really, and I told Mr. Henderson, I don't want to leave here tonight by saying we're going to pre-approve up to this limit, but the developer could come back later, give reasoning as to why they want longer blades, and then I feel like it's, it's too late at that time to do anything about it.
Well, if we do go with a bigger turbine, there's a lot of steps between now and then to get to that point, is that we will have Santec take their data and issue a new report, and that'll be part of this, part of the thing, picking a turbine. If the turbine says it's gonna, we have to deal with Fish and Wildlife, the federal agency, and we pick something that's gonna kill more birds, they're not gonna let us do it. So, and one thing I will say this, I've been in this business for over 40 years. We've done a lot of radar work with birds over the years, tracking them and seeing where what they do with wind turbines and stuff. And what's been very interesting is the geese and the ducks. When they fly, they're looking forward as well, and so they will go around. We got big tracks of wind turbines down in Texas on the coastline. You can see them; they'll go around them. The ones that you've got to be concerned about are unfortunately the hunters, because they're looking down for their food and they're not looking forward, and that's the reason they run into so many structures. But we will, if we go beyond a certain height, we will get Santec to redo their report. Update their report.
The visual impact, the visual impact, Stantec can't
right.
wipe that off.
No.
And so I'd like to get the input, I've kind of stated, my big hang up here. I'd like to get the input from the other board members as to whether the height limit is a major concern for the rest of you, as it is for me.
So you're putting in, the turbine to be able to handle the longest blades possible, so that when you repower, or you're gonna put in the longest blades 639 feet?
This matrix is what's available today. These are the turbines that are available today. There's some other turbines that are available, we wouldn't use them. These are the ones that we would use.
And those are capable of having that type of height then?
Yes. Yeah, these are the turbine manufacturer specs is where we got this information from.
Are those the ones that are in Salt Creek 1 then? Are they as big as you're gonna go, or?
So that's actually GE, that's a smaller turbine.
This is the one that's in Salt Creek 1.
Okay, so Salt Creek 2, you're going with a bigger turbine.
Could be, we could go with the same one. As I explained to this board of supervisors, we take a developer, we take it up to a point where we get all the permits and the interconnect agreement and the land leases and all that. And then we turn around and we sell it to somebody, like Nexera. It could be Wine, it could be Mid-America, it could be, there's all kinds of people that could buy it. And then they bring the turbines, because that is very expensive. We're talking So I get it up to a point, and they don't wanna deal with, they just wanna have a project that's already ready to go, so they can, take it, so they bring the turbine and substation equipment and all the underground equipment. They supply all that. And so that's the reason I'm unable to tell you which turbine, because I haven't sold this project yet, and I can't sell this project until I have it permitted. So, and we're saying 60 days prior to construction. We're actually, the turbines will probably be picked much sooner than that. And then we'll get the engineering done, and we'll update any reports we need to do, and then we'll submit that to the county.
Have you ever heard of them painting a blade black so that the raptors can see that turbine spinning?
There's been a lot of work over the years on doing that, and what they found is the white is the most part. They've done red and white, they've done black, they've done all kinds of different, up in Altamont, that's outside of San Francisco. That is a bird migratory path that some turbines got put in, and that was done back in 1984, I think, 1983 or 84. It's been around for a very long time. And there has been so much work done on birds and turbines up in that area. They've even put the sounds on them, you know, the high pitched sound, they've done all kinds of stuff. What they found is just getting the turbine, and those are short, those turbines were short to the ground, they were the old technology, they were 100 kilowatt size turbines. And today we're putting up, like in phase one, those are 2,000 kilowatt turbines. And so what we found is by going bigger, I mean, not bigger, but by going taller, and then reconfiguring the nacelles. So what you see the nacelles coming down the road, you'll see there's no handrail on the top. That is visible from the side. So what we've done is we've put the handrails very short, and inside say this is the top of the nacelle, we put a way inside here, so the climber can still be safe. But if you put them out like a regular handrail that you would have on a conveyor, on a silo, that's where the birds will stay for hunting. So what we've done is we've rounded the backs from all this stuff we've learned from Altamont. We've rounded the size of the nacelles so the birds can't stay there. And so they can get on the rail, but they can't see anything except the nacelle. And so there's been a lot of work done over the years to make these bird-proof the best we can. But I'm just giving you a small example of some of the stuff we've done. And getting rid of the lattice tower. In the yellow turbines, they had like the big transmission line where it's all open. We got rid of all that, so everything now is tubular towers. And that's also helps with the birds.
There was a question by a gentleman here who was concerned, I don't know if he has any turbines or not, but it sounds to me like he's concerned about road ditches and springs that run through the ditches and the tiling that he has out of his fields running through there and the fences. I imagine that's probably because when they're widening the roads and stuff, they're kind of encroaching a little bit close upon his property, or where he has tiles going into the ditch that they could get plugged up and stuff, and then they'll get taken care of for him.
Right. First of all, we signed all the agreements that of the land, where the land is going, where we need road access and all of that. We've done that, so we're working with those landowners. So we're not gonna just go and get on near someone's property. If we have to get near his fence, which we don't have a lease to, we'll have to go and get a lease, work with the gentleman, and we'll be just like the pipeline. I mean, we've learned, we've learned how to go in there, work with the farmers, work with the ranchers. It's a lot of work, just like in phase one, we work with all the landowners and all that. And we make sure that if there is a fence, we go and talk to them before that. There's a fence crew always on site.
And to address the drainage concerns, that is addressed in the road use agreement. There are obligations to repair any drain tile in the road use agreement.
I do have a concern with the money and the promises of the money, 22 million for schools, 30 million coming in and things like this. Schools are absorbing lots of money and putting out lots of children that can't read. It wouldn't bother me so much if more kids were graduating with better degrees than aren't. But other than that, TIFs can come in and take that money. And it can be put to other things, paying off the debt that Tama County incurred over the years. Would probably be the first thing to be done with the money. But that has nothing to do with you basically, but in the contract in here that was there, that was stated $22 million would go to the schools.
Well, you know that better than I do.
If the way that the property tax scheme is set up, especially with the special valuation assessment, certain amount of money does still have to go to the schools. That's just how it is. Now, there's also additional funds, right? You're having more tax dollars, they're gonna go to the county, and the county can do with whatever they need to do with those additional dollars. But there's still a set amount that's going to the schools, no matter what your supervisor said.
It's a state law, it's part of the state.
Okay, so that's based on the revenue that's gonna come in.
Correct. And that's the reason the 1.3 million is not part of that. It's not, we deemed it not as property tax, we deemed it as a fee. So it goes straight to the county.
So they can use it where it's necessary.
Correct.
Thank you.
Back to height.
Yeah.
That's what I was just gonna say, go ahead.
What do you have,
Well,
discussion?
so basically you're saying that not being able to pick it is because they want you to go to fewer turbines. So can you stay at the 27 in height?
Well, what I was saying is that the reason we added the original, the CUP had 8 turbines on it, and we're now at 12. The reason was is that we were asked to see if we could get less turbines by the board of supervisors in negotiations. And we said if we do that, we have to go with bigger turbines, bigger output turbines, because we have a 100 megawatt interconnect. We don't want to put in 90 megawatts or 80 megawatts because, you know, we spent all this money to get the interconnect at 100 megawatts. And those are not cheap. I mean, we're talking millions and millions of dollars to do that. So, and then we have the substation build and all that. So we want to maximize what we have with MISO. And so to do that, we added more turbines so we can have the opportunity. I'm not saying that we will do only 20 turbines and use real big turbines. Maybe the new owner wants to do all 27 turbines and smaller turbines. It's not my decision, it's who we sell the project to.
But you had added a 500-foot tall turbine, and you didn't have a 500-foot tall turbine on your initial application, so you included a shorter turbine, you didn't just go taller.
We did that because one of the people that we're talking to have some of those in inventory, and they were asked us.
Because those are the ones for Salt Creek 1. John?
Is there a certain, is there a certain area on the map that it would be, with avian studies, like get toward the lake, you know, that sort of thing? Is there more birds, you know, flying there or what have you?
That, I've not studied the report, so I could get Sandtech, any comments for you guys.
Yeah.
I don't know.
I actually have some information on that for the DNR, from the National Fish and Wildlife Services,
Who's talking? Oh, I see, you're right.
if I may. So, the 2 birds you mentioned, most of the time, those birds are in marshy, swampy areas, so if this project were down next to Otter Creek, that might be a problem. But those birds that you mentioned typically do not have it.
Yeah, and I had identified that the 2 that are in Iowa's state endangered.
Endangered species, yep.
Yeah,
And then,
most of them were going under, but it was the water birds curd, and it was the, you know, like turkey vulture.
the Iowa DNR says that most of those, including the water birds, are gonna be, they spend the majority of their time near water. And then the National Fish and Wildlife Services, the National Fish and Wildlife Services talked about, they put out a study in 2022 about what kills birds in the US. Wind turbines account for 2 to 3 birds per turbine per year. In that year, with the number of turbines in the US, that equaled to 430,000 birds a year. Cell phone and communication towers, 45 million. Environmental toxins, 72 million. Cars and other vehicles, 80 million. Existing transmission lines overhead, 130 million. Low-rise buildings such as your house, 97 million. High-rise buildings or buildings more than 3 stories, 976 million birds a year killed. The number 1 killer of birds in America are cats at over 1 billion.
Because there were a total of 17 of those species of greatest conservation need that were observed at survey points or incidentally within the survey area. So it's not just the 2 that stayed endangered, there were 17 species of greatest conservation need. So, you know, I really, I'm having a hard time just kind of, you know, writing you a blank check and saying whatever turbine your purchaser decides is gonna be good for Tama County. I mean, one of the comments is, do what is best for Tama County. And I don't know if this 5-member board just wants to write a blank check tonight, not knowing if 639 foot, that's taller than the St. Louis Arch. St. Louis Arch is 630. And I just, I would hate to have my name associated with a board of adjustment that approved a project not knowing the height of the turbine. I'm sorry. That, it's just a real stickler for me. And, you know, your application just did not state it, even though it is required. It is a submittal requirement.
Do the landowners, do they even know that they possibly have one of those big boys?
Yeah, they,
Yes,
yes,
yeah, we
do.
Yes, we do. Yes, we do.
Yeah.
Sure they do.
We work with the landowners about, the way the process is we'll come in and talk to the landowners and we'll say, okay, we need this big piece of property where, you know, we lease it from them. And then we start figuring out the turbines, and then we start doing these reports, these studies. And then it starts, okay, how far back from a house, how far back from a wetland, how far back from right-of-ways, and then the bird studies, and then the plant, wildlife studies and all that, and it just starts shrinking, and it just starts moving turbines around, and when we finally get it to where we're pretty sure this is where we wanna put turbines, we work with farmers. We do all that before we submit to the FAA, because when the FAA rules, that's it, you don't move it again. I mean, it's just, that FAA is the hardest permit that we get. And so we work with the landowners and say, okay, this is where we want to do, and they'll, it works very well, is that people want to put a road here, and they say, no, I want you to move it 15 feet further because my tractor is so wide, you know, I don't have to, it works in my roads, or I need you to do the road this way. And so we submit all that to the FAA, not the road part, but the terminal location. And when the FAA comes back, they might have us move a turbine or so, because whatever they think is necessary. Because we already have to do all the microwave studies, all the communication studies. We have to have all that stuff done before we can submit to the FAA. That's the reason this is the last permit that we get from the federal government. Then we go back to the landowners and say, okay, this is where we're putting the turbines, and these are the roads, and then we'll adjust things back and forth. But yeah, the landowners are involved in this process.
So how close to a turbine, if you had an accident and there needed to be airlift come down, how close can they get to those?
I've been in a lot of helicopters, we can, in wind farms, and we can get pretty close. I mean, you're not gonna get unsafe, don't get me wrong, you're not gonna fly right up next to it.
No.
But you're gonna be 1,000 feet away from it.
You can go that
Yeah.
close.
For what it's worth, in other counties, they had talked to people that had done trainings and, you know, test runs
Oh.
in wind farms, and they have said that there's been no impact at all when
I actually talked to an air care pilot when we did a training by the Vienna project. He said they can land as close to 100 foot next to turbine. They have no effect on them.
And they landed there during the traffic.
Yeah, they landed approximately 150 feet away during the training.
Is there a reason those people can't go to the front to speak? We all had to.
I can hear it.
Do you do the turbines out in the ocean too?
No, ma'am.
Do you do those? No.
That's
I
a
know.
whole different technology there.
I just had a question on the good neighbor agreement, you know, and it's, shadow flicker, it's 30 times per year, you know, that sort of thing. I don't know how you gauge that anyway, somebody'd have to keep track of that, but if somebody signs the good neighbor agreement, do they waive their rights to ever dispute that?
Typically, no. If you're having more shadow flicker than what is required under the ordinance or what you've agreed to in the good neighbor agreement, no, I don't know.
I thought I read that in there, that you waive your rights.
And I don't know what the good neighbor agreement says, but typically you still have the ability to say, I'm getting more shadow flicker than I signed up for. And the developer will.
Well, they didn't
typically come
sign
in.
up for anything if they're not non-participating, I guess is what I should have.
So
specified.
non-participating
Yeah.
that have not signed a good neighbor agreement.
No, if they sign a good neighbor agreement as a non-participating, you know, entity, acreage, whatever, yeah, do you waive your rights to ever question, you know, this 30 days?
If you have waived the flicker requirements, then.
I don't know if that's in there, that's what I'm
Right,
asking.
and that would have to be something that would be negotiated with that landowner when they sign the good neighbor agreement. I don't know what's in the good neighbor agreement,
Okay,
off the top of my head, unfortunately.
that might affect a few people, you know.
I understand that that is something that they can negotiate in their good neighbor agreement as part of their own personal rights on the
They
property.
can negotiate that, it's not everybody gets the same good neighbor agreement that is
We
there.
offer the same agreement, but then everybody negotiates differently.
So you're sending out some kind of lease now?
The landowners for which a turbine or a collection line are currently planning to go through have already signed a voluntary easement, which has all of the rights that they need to be able to construct the facilities on those properties.
Nancy, that's the side paper right here, this is all the leases that they submitted.
And those have all been reported in the county reporter, or at least the memorandums of the same.
Now, we do have obligations, at
Well,
least,
there's people that are getting letters now.
Probably for notice of these meetings.
and also
Yeah.
to keep the, activate the leases. I mean, you have lease options now, we're starting to activate leases.
But they would have already had to voluntarily sign up to be part of the project
This
in
is,
that case.
because there's a development period of time and construction period of time. So we're in some of those timelines, so we're activating. This is a lease option.
Want to ask a question on that?
This is here, time period for the board of adjustment right now. Did you have something, David?
No, we pretty much answered most of mine, other than I would like to pin down a height too.
Appendix R, which is TV analysis, says communities in the area could potentially have degraded television reception due to the location of wind towers. One is KCRG, one is KGAN, one is KWWF. Page 5 of Appendix R, the last paragraph, nevertheless, both cable service and direct broadcast satellite service will be unaffected by the presence of the wind turbines and may be offered to those residents who can show that their TV reception has been disrupted by the presence of the wind turbines after they are installed. Because I think a lot of those are line of sight, am I correct? Line of sight. So what does it take for someone, or, I mean, should that be something we should put down as a condition that if, or how common or how rare is that?
It's very rare, but we have done it. We did it in Illinois, back, they had, there, what we ended up doing was put
so was that, I mean, was that hard for them to get that to happen? They didn't have to take the court or anything like that?
No, they came and talked to us when we'd already said, yeah, we'll take care of it, they did.
So you're paying their cable TV?
That's been, that was in, year was that, that's seven, those, don't remember the exact details, but I know we put them in. I couldn't, I don't know if we're still paying their bills or not.
And then emergency, services. That was in the summary for appendix Z. So I made it all the way through my book. So they say, in the unlikely event that an operator of any land, mobile, or emergency services, and I don't know if JC's still here, believes that their coverage has been compromised by the presence of the wind energy facility, they have other options to improve their signal coverage to the area. This includes the optimization of surrounding base stations or the addition of a new sector or cell site. Utility towers, other communication towers, or even a turbine tower within the wind project area can serve as the platform for a new base station, cell enhancer, or repeater. The project developer would be responsible for working with any impacted licensee to satisfactorily resolve any issues that occur. So has that ever happened?
Never has, but by the FCC, we're required to do it if we do impact it.
Say that again, sir.
The FCC, if we do an impact, we impact any microwave, 911 service, any of that, we have to take care of it. That's under the FCC license.
Okay.
So, and then Casey.
So after the meeting, there's been so many, I can't remember, one within the last 2 months. Linda, I think it was Linda Moeller who had brought up the 911 communication project that we have. Obviously, as a new sheriff, I've been having my focuses on what we need to do to move forward. So at that point in time, when she mentioned that, it wasn't even a thought in my mind about the 911 project. I was not caught up to speed with the previous sheriff in the windmill projects and where the 911 towers, microwave radius between the towers is how they're situated. So I reached out to Raycom in Marshalltown. I also reached out to Jacob Reinig, who's our new 911 director, and I felt the need to be informed on whether or not these windmills and this project is going to interfere. Prior to that, I did reach out to Sean, and I met with Sean and Bob, and they provided me 2 studies that would help shed some light on how this project may or may not affect the 911 system that the county owns. In talking with Raycom, reviewing the study, talking with Jacob actually went so far as to plot on Google Earth all of the coordinates of the windmills that are being put into phase 1 and the phase 2. I draw a blank on it. He plotted all the relevant data for the windmills that are going to be put in. Based on the line of sight in confirming with Raycom, there appears to be no interference that should happen with any windmills that are put up. Now, obviously in my conversations with Sean, this county has spent $6+ million on a 911 system. I personally do not want any windmills to interfere with that because that's our lifeline. But I'm confident that based on everybody that designed, built, monitors, maintains
of the kind of visual, Google map that, Jacob provided, I'm very confident that there is not gonna be any interference with the windmills and the radio system. Cause obviously that's very important for me, it's very important for all the emergency responders. In my conversation with Sean about this, I also feel very confident that basically backed up with federal law and the FCC, if there is any interference, they are required to make adjustments, so that way there will no longer be any interference.
So what is that, a repeater that needs to be added? Is that what I read?
It could be a repeater, it could be that we move one of their towers, or have a tower.
Oh, wow.
But from all the studies we've done, we're not gonna impact the microwave sites or any of that.
And for what it's worth, I did talk to the project manager who designed the whole ACOM project, and he was not concerned in the slightest about any interference. And he also kind of calmed our nerves in saying that regardless if there is interference, every project that we've done that has had windmills, it's the windmill company responsibility to rectify that issue.
And Mr. Henderson, our attorney, he, and I, kind of last minute, but he put together a resolution, and he's unable from his, laptop to print it, and we're having some problems with the screen. So if Mr. Henderson would just like to read that resolution. He had sent it to me about 3 o'clock this afternoon, but, the two entities, the two attorneys, have made some changes. Now, if we were to sign that resolution, I mean, it would also need to be signed by the developer, am I correct, Mr. Henderson?
No, it doesn't have to be signed by the developer, it's still the resolution of the board, so.
But if we went with the resolution, it would be a condition of our approval tonight.
Right, it's a conditional use permit, which means it's a permit with conditions.
And Mr. Roberts would need to sign, if we approve tonight with conditions, he would need to sign that as well, right, Laura?
So, but I was different.
The conditional use permit, he needs to sign it.
We prefer that, I suppose he doesn't have to agree to the conditions.
Okay.
Normally we would have the applicant sign it if they agree with the conditions, and that would make it absolutely valid on both ends. I don't know the other situation.
Is this appropriate time for you to read the resolution?
Sure, and then you can ask the applicant if that sounds like that they're agreeable with conditions to, if you want.
Okay.
Alright?
Do you want me to try it?
No, because he's going to change it, but I mean, you can kind of go through.
I
This is
gave her a
3 year
current
old.
one.
Okay.
Do you want me to charge it up? I just have different ports on my laptop.
Oh.
You might be able to, I just didn't have the right ports on my laptop.
Okay. I do have an HDMI output, I'm just hooked up to all the camera stuff, so we get the HDMI over to the middle, I think we can try to make that work. So many cords.
And I don't know if I have the support of the 4 board members here for this height, restriction.
HDMI's on the side.
Madam Chair, I think. Once we do it, they can consider motion. The resolution was an attempt to, deal with some of the issues that have been raised by the reports and also by the chairperson in her deliberations with the documents as well. And the resolution just states on October 14th, 2025, Tama County Board of Adjustment, BOA, conducted a public hearing on the Salt Creek 2 application for conditional use permit, which is called a CUP for short. At that time, the BOA received comments from the applicant Salt Wind Creek 2 LLC, which we call the applicant, represented by attorney Kelly Orton, zoning administrator Laura Wilson, and members of the public. And then if you decide you want to move it, I just put a blank in here. After the hearing was closed, BOA member blank moved and BOA member blank seconded the following motion, colon. The CUP application submitted on December 20th, 2024 is hereby approved with the following conditions and or exceptions. Number 1, wind turbine approval. Prior to issuance of a building permit and commencement of construction, the applicant will submit the manufacture and model of wind turbine to be used for the project that has a total height that does not exceed 520 feet, and supply an engineering report which certifies that the final wind turbine is within Tama County requirements and accepted professional standards given local soil and climate conditions. Number 2, collection lines. Legal rights for a connection for collection lines connecting wind turbine 25 and 26 to the remainder of the project have not been finalized. As a condition for approval for collection lines connecting wind turbines 25 and 26 to the remainder of the project, the applicant must provide the zoning administrator with either of the following. A, evidence of legal property rights for parcel number 11.818.300.002, 10.13.400.004, 10.13.400.004, and 10.13.300.004, or evidence of legal property rights for an alternative route for the collection lines in the form of an easement or property purchase. The deal with that particular situation is that right now, there are a couple of turbines that still need to be worked out. They can either be hooked into the Salt 1 project, which is alternative number 1, or number 2, they could be hooked into a totally separate route. But as you know, these turbines collect electricity and they have to distribute them. And this has to do with collection lines, which would send electricity to the place where it could be used. It's just an inside issue, but it's one that we addressed in the resolution. Number 3, wind resource allocation, which has to do with the turbines interrupting wind flow for other turbines. It's always a concern, but it's one that the applicant has addressed with a solution, and this would be it. Regarding possible impact of the project on other existing wind turbine operations, the applicant will not construct a wind turbine within 5 rotor diameters or with 1/2 mile from an existing wind turbine. Should the project be shown to have a significant negative impact on the available wind energy to an existing wind turbine, the applicant will mitigate the impact. So they're going to deal with that if it happens. I assume it's pretty rare, but it's still something that was raised in the account. Number 4, field wetlands report. In connection with state certificates, the applicant will be commissioning a field wetlands report. This report will commence at least 30 days prior to commencement of construction and be provided to the zoning administrator as soon as reasonably practical thereunder. This is a state requirement, and the reason that they have to do that at that time is it has to be very, very current. So they can't really commission it until within 30 days of construction. So that's something that they will do because they have to, and then they'll submit it to the zoning administrator, so they'll have it. Number 5, time limit of CUP approval. The CUP approval shall remain valid for 2 years from the approval date of this resolution, unless the applicant substantially commences construction of the wind turbine system or requests an extension from the zoning administrator. With the last application, that it took some time before they got started, they know that, and they're willing to comply with that by getting a substantial start within 2 years. Number 6, additional future applications. The applicant filed a conditional use application for an electrical substation on October 10th, 2025, and that will be considered in the future. Yeah, it is also anticipated the applicant will be filing an application for LiDAR facility approval in the future as well. And the final thing is transfer of the CUP. This is a request of the applicant, and it's well reasoned. If the applicant sells the project, the CUP may be transferred by the applicant to the eventual purchaser. And then there's just some line about what's passed on this day and the place for the chair to sign and for it to be attested by the zoning administrator.
We can double check those parcels too, if the numbers you have are the same.
Okay? So, can we change that right now?
That came from your letter, I think. Yeah. So.
And Mr. Henderson, it's, I think your first paragraph said Salt Wind Creek, I think it should be Salt Creek Wind.
Thank you.
Yeah.
Not that I've made that decision.
I think it might have been up under 1.
I'm a very interested here.
Yeah, third line down. Comments from Heather. Salt Creek Wind.
Madam Chair, we'll get those changes.
Make those changes.
Do we need to specify that the LiDAR requires a CUP as well, it just says application?
No, we don't need to do that.
No.
This is anticipated.
Otherwise, just say CUP application, but it will also need a building permit after a CUP, so it could be construed as just a building permit. Sure, you two go that was.
How we gonna know that?
Mr. Roberts, do you have any comments?
Yeah, when we were negotiating this, the number one was that we were willing to do the 520, but if we went to a bigger turbine, we would renew all the reports to do that, and that's not covered in here now. So this is, it's basically 520 or nothing, and that's gonna be very difficult for me to limit me to be able to sell this project. And meet with the board of supervisors as requested that we try to do fewer turbines. I mean, I'm willing to like do the 520, and anything over that, we will update the reports. And if there is, the thing is we have to work with all the federal agencies anyway. So if we go with a bigger turbine, we have to go to the federal.
But we still have the visual impact.
But the visual impact, they can't do anything. That's the one thing that, right, that's the one. You got the ones.
We can believe that.
do that at 520, only have 2 turbines.
Right, and so, this is what would, I mean, if we went up to the next height, it would be 546.4. That's the next tallest, 546.4. That would give you, 2 GE models. And, that's GRE.
But see, the problem is the deep, like, we'll just use Next Air for example, they have, turbine supply agreements, they go and negotiate with all 3 of these, and then they end up buying something from, say, GE for year 26, and then maybe year 27, Siemens gets the contract, or, and that's the reason it's very hard to limit these. I know the people that we're talking to deal with these 3 big manufacturers. But the 520, that gives you 2 turbines. I mean, we would need to go much higher or be able to wait to bring. I mean, there's 3 turbines over 600 feet. Because they're so big already.
You can't hear them, but.
Yeah. I can see them in my backyard. Yeah. It's interesting. I've been in this business for a long time. It's hard for me to pick turbines that come by.
I mean, it's up to someone, if you guys want Mr. Henderson to change that, you know, height limit, to, you know, one of these other heights in this.
It doesn't sound like he's gonna be able to go that low, right?
It limits, I mean, if I did that, that means I have to sell the project to someone that has a GE agreement that's in place in the same timeline. So that really limits me who I can sell to. And it really devalues the project. Because right now I'm negotiating with 3 companies, that will take 2 of them out. It might take the 3rd one out because they might not have any GEs in inventory ready to go.
One of these is an SGRE.
That's a Siemens,
That's a Siemens.
yes ma'am.
So the 511.8 is a Siemens.
Yeah, this, SGRE is the Siemens, and then Vestas. Vestas are made in Colorado, the Siemens are made in Kansas, and GEs are made in Florida, Pensacola, Florida.
So if we were to go up and include 546.4, which is another GE, so, it would still exclude all of the Vestas.
Yes ma'am.
I think I could, guarantee that we're gonna have, a 600-foot tall turbine if we, don't identify that tonight. And I really wanted to leave here tonight knowing what the height of the turbine, was gonna be. That was in the, final piece of development.
do it based on hub height. That's the middle of the cell. And there's two turbines here with 120. I can still use the bigger rotors, but I just have to put them under like a 105-meter tower.
So what would the final height be?
About 45 feet plus. I mean, we could get under the 600 foot.
Yeah, I mean, that's,
But the thing is we're at 500 feet now in phase one, and you're really not gonna notice, I mean, the difference between that is not that big of a, because it's all blades. It's in the cell that you really notice.
no, I don't think so, because I live 26 miles north and I can already see them.
Right, because they're not spinning right, yeah.
Well, I can see the blades, I can't see the nacelle or the tower.
Okay.
Need some suggestions here.
So you run a shorter pole, but you use longer blades,
Yes, sir.
and then won't be seen as far away.
Right, it won't be, you won't have the set line.
You mentioned there's some problems with doing that earlier.
It's, if you get too low, I mean, I wouldn't wanna go any less than about 105, 110 meters.
So what's the,
I mean, I would suggest that since I've got a GE at 110 meters, I can get Vestas to drop 10 meters out of these. They'll probably go to 105, because that's the tower they already have.
So give me an example of what you're talking for hub height, road diameter, and total height.
Well, it would drop on the Vestas, it would drop it by, say, 50 feet, so, close to that.
540, 550?
So the 590 would go down to 540.
No, I was just based on the 640, the 639.
Oh, the 639 would go down to 600.
Would go down to about 580, about 590. 590.
You still do the studies then,
Yeah, I wanna do the studies, not redo the study, totally take the data and look at that extra space at the top, and, cause we've already studied the bottom side of it, but we would, get Scientech to update that, that's what we originally agreed with, is at 520, anything over 520, we would have Scientech update the report. That's what I thought was what we were talking about, and then when I read that just now, I didn't have that in there, and I was like, whoa.
Yeah.
So the 520 really doesn't make any sense because, and I had, kind of asked Mr. Henderson about that too, it was just kind of, a figure he collected, because it wasn't, the total height of any of these turbines, 520. And so I would just need a motion if someone wants to have Mr. Henderson go back and put that language in, or what Nancy, read there. Do you still have that contract? Yeah.
The language in one that you removed,
Did
they're talking about adding it back.
I originally used,
Did you say the original version?
the one that allowed for them to come back in again? Yeah, I can drop that in if you want.
I mean, I would wanna make sure I had a board member that was, gonna make a motion to that effect before you do that, Mr. Henderson.
Do you think about using the language that you modified with the red line?
But then Mr.
You're talking about the one with the red line, or?
Yeah, Mr. Roberts would have to, kind of give us some idea as to what he had said he would drop the hub height down to.
Say 110 meters, that's what the GE is.
So the hub height would be 110,
Yes.
and then the rotor diameter.
Well, right now we're at 150 on the Vesta, so we could keep it at 150. But on the GE at the 110 is 137 meters, so it's even shorter, so. And then the Vestas would be 105 meter. So that's what I'm saying, there's some room to play with the towers. But you got, Vestas will stay within their own specs, and Siemens with their own. What I'm talking about is this is 150 meter on 120 meter tower, so we take that down to, they have 105 meter tower. And it's still 150 meter rotor, and GE has the 110 meter, this one, 137 meter rotor. And so if we could just say we wouldn't go over the 110 meters, that means Vestas is just gonna drop down to 105. They're not gonna build a special tower just for one project.
So you would exclude the bottom three Vestas. Or no,
It's only two.
Yeah, it's only two, you're
That's
right,
right.
yes, you're right.
Yeah.
So this one, there's two, and 105.
Yes, ma'am, correct. Yeah, the ground, your ordinance says you can't get any more than 75 feet.
And that would still comply.
Yes, ma'am. Because it complies with the 105 and 150 meter.
So these are options, but these are still options too, correct? The ones
No,
that-
this just takes that times that.
Yeah, but I'm saying the short ones that I had hoped that you would agree to are still options.
They definitely are, and it's based on who we sell the project to, what they have in inventory, that they have access to. So, it's like when we sold Salt Creek 1 to Sarah, they had these turbines actually sitting in Kansas. That's the reason they were able to get them up there, getting shipped in, because they'd already bought them from, cheap in Pensacola, and had them in, Garden City, Kansas, so the big store yard they have there.
I have that original language if you want to read it.
Okay. Mr. Henderson is gonna read the revised, document now, the revised resolution, just that number one, I'm assuming.
This allows for them to come back in again. Wind turbine approval. Prior to issuance of a building permit and commencement of construction, the applicant will submit the manufacturer and model of wind turbine to be used for the project and an engineering report which certifies the final wind turbine is within accepted professional standards given local soil and climate conditions. I think in the original, in the one I just recently, I added a couple words about having to comply with county specifications. I put that back in. I would recommend it. But this is what it says. In addition, should the applicant wish to use a wind turbine with a total height exceeding 520 feet, the applicant will submit an updated avian use report or an affidavit from an expert that certifies no significant impact to the bird population by the taller wind turbine.
And a hub height no greater than 110 meters.
Do we have it?
Yes, please. Say that again, Laura. Sorry.
Well, I mean, I think with that.
And I just wanted to make it known that a lot of the studies in here used taller turbines. The avian study was one of those that said we're gonna use a shorter turbine. Some of them, just really didn't identify height, and it is challenging to assess the impact on a county when you don't know some of them, studies use 508, some of them use far greater, and so, we have to keep that in mind. But yeah, I'm not a tree hugger, I mean, I love my feathered friends, but that's not my main, impact here tonight, is to just protect the county, knowing the proximity to Otter Creek Lake and Park.
Nancy, will you keep an eye on the time, we're getting close to our 3 hour mark, you can extend it by a vote, which I would recommend at this point.
But we don't have to do that till 9.
Yeah, but that's in, like, 6 minutes. That clock's a little slow.
So what would we have to extend it, like 15 minutes? Or
I would just say, because we're so close to getting this done, we'll extend this until we're finished.
Okay,
Because the only other thing after you guys vote on this is, when we don't have another agenda.
right.
We'll knock this out. You'll have your vote. Sign some paperwork. So I don't have a timeline for you, but we would want to make sure you get that vote in by 9 o'clock, so about 5 more minutes.
Are we ready? Sure.
Okay, great.
Read fast.
Wind turbine approval. Prior to issuance of a building permit and commencement of construction, the applicant will submit the manufacturer model of wind turbine to be used for the project and an engineering report which certifies the final wind turbine meets county requirements and is within accepted professional standards given local soil and climate conditions. In addition, should the applicant wish to use a wind turbine with a total height exceeding 520 feet, then in parentheses, with a hub height of no more than 361 feet, in paren, the applicant will submit an updated avian use report or an affidavit from an expert that certifies no significant impact to the bird population by the taller wind turbine. Now the question becomes, so who's gonna say that's acceptable, right? We don't answer that question. So maybe somebody needs to discuss.
You mean the bird study?
No, if the applicant wants to use a different, I mean, who's gonna sign off on that, say, okay, that's fine, then, that's okay.
So that would have to come before the Board of Adjustment rather than just the zoning administrator, you assume.
Well, that's, you can do either, I think, you could assign that responsibility to her to make sure that it's compliance, or you could have it come back here for the minimum. I don't know if they want to do that.
Would you rather we review that ourselves or allow Laura to just? What do you guys think?
Laura's good.
You as the board are tasked with the decisions that are more subjective and have more leeway and more give and variance, whereas, my position is more adherence to the ordinance, with smaller variances, especially if we have variance to the ordinance, then that still comes to you as a variance application in other situations. So if it's a strict, they come to us, it's under your threshold, then absolutely, send that to me, but if you're discussing if their higher turbine request meets your criteria for their studies, I would suggest having it come back to the board.
What would be your criteria?
Oh, I mean, to accept it at that time? Well, I guess, I don't know, I'd have to read the bird study at that time, and you're saying you're gonna build a taller turbine. It's still gonna be with, underneath the 600 foot. Right, identified here.
I think that's what Sean needs you to discuss.
Yes, yes. I don't know, Mr. Henderson, what would be our criteria? I mean, that's why gather if we don't know what it is that we're gonna be looking for with the data that's gonna be given us.
You need to do a meeting.
Yeah, maybe, yeah. Can we just vote, all aye?
We need a motion in a second.
Yeah, a motion to extend this meeting, well, we're not gonna be here an hour from now, let's just say half an hour.
Sure.
Till
I make a
9:30.
motion to extend it through 9:30.
Nancy
I'll second.
and John, all in favor say aye.
Aye.
Opposed, okay, so we're gonna still be in session legitimately till 9:30, but we're not.
I think somebody on behalf of the county has to say, yes, this is acceptable. And, you can have the board do it. You kind of laid down the criteria. You said, if they come back with a bird study that said it won't, significantly affect the bird population, then you would consider a different height, but I'm not sure it specifies what height you can shoot for. You say if it's a limit of 600 feet.
Yeah, with the 110-meter tower height, that puts us under 600 feet. But the study will have to meet fish and wildlife standards. Affidavit or the report. Because that's what, Sanzac's gonna do nothing without meeting the standards.
I may be missing here, but I don't see the new level. You just say, if you want something higher, we'll consider it up to this level. But you have to come in with these types of things.
Up to 600. I mean, you
Well,
want that
what we're
language?
saying is that any turbine with 500 tip height over 520, because there's some questions as the bird study's been done enough up in that height, 520 and 600. Yeah, we're gonna have Santec take another look at that if we end up picking that turbine. And it'd be still to the same standards as Fish and Wildlife, like all the rest of the study has been done.
But should we put in here that you consider raising it to a height of 600 feet? I know the hub height is in there, and that may be part of the calculation, it's not clear.
What we can do is take out the hub height and just say no greater than, can't be greater than 600 feet. Tip height.
I think it's
That might
clear.
be actually cleaner.
Okay, so I'll change it. But then you still have to say who's gonna say that's okay, unless you just wanna automatically approve it, if they come in with the avian report and the affidavit, and or the affidavit.
I have a suggestion, since it would be approving it as a group project, you could say that you would only charge it as a single cup review instead of as 27 cup reviews, as long as you say that you only vary the turbine height. I don't know if they plan, in our wording, it sounds like they allow you to vary the turbine height within your model, but you would keep the same turbine
Just go to
height.
one turbine.
The same height for every turbine, right?
Correct.
So, you could have wording that says, we would only chart and review it as a group project update as opposed to when you get required for your locations, it says 27, because you're also approving locations. Then we're not overcharging for your follow-up meeting, would that be acceptable for both parties? I don't think we need to add that language in, but verbal agreement. Ask the lawyers.
I don't know that it needs to be added in there, does it?
With the administrative fees.
The Board of Adjustment can vote to combine all the conditional use permits into a single approval or denial of project. Should we just go ahead and do that, Laura? Yeah. And so, do I have a motion from anyone to, and we don't need to do roll call on this, do we?
Let's do it just to be safe.
Oh, all right.
Our training we had was never to do a roll call, but.
So I
I'll make that motion.
So John made the motion to combine all conditional use permits into one single approval or denial.
For the 27 turbines, we're not doing this.
For the 27 turbines, yes. Do I have a second?
I'll second.
Nancy seconded. And then we're gonna do roll call. So we'll start with David. Nancy, Joe. Scott.
Aye.
John.
Aye.
And I'm an aye as well. That carries. Okay. So now we're down to just Board of Adjustment vote and the writing of conditions.
But on this one, let's go back, if you don't mind, on the bird study. What I'd like to do is if that distance between 520 and 600, we bring you a report that meets Fish and Wildlife, do we need to come back to, it's a federal standard, we just give it to Laura, and then that should be all we should do. We don't need another hearing, do we? So.
Give it to you guys. That's your option to make that.
Yeah, I think
Just
Laura.
Laura and Wood.
Should we stand?
Yeah.
So we submitted the zoning administrator for approval.
Yes.
And
approve with conditions negotiated by the lawyers. I don't know if you added, need to add, and per the resolution provided by the lawyers. No, how specific you wanna be on that? I like specificity, it's better than more.
Madam Chair, may I ask a point of reference? If this agreement is settled the way that it is, the wording it is in conflict, I believe, with the development agreement and where that comes back. I believe that it comes back to the Board of Supervisors for our already approved development. That's something for the attorney, that we had already passed in our resolution and in our development agreement, that all issues that would be follow-ups would come back to the Board of Supervisors, not the Board of Adjustment nor the zoning administrator. If that was submitted to the zoning administrator, it'd be a ministerial action. Just to avoid a technical mistake, because we will have a meeting.
Thank you. That's a good point. Because we already addressed things like substations and radar and aircraft detection radar tower. It's going back to you guys.
It's a good question, because we have standards now in 3 different locations, and that's a valid point. I think these may be more restrictive than some of the things you agreed to in the development agreement, but it seems like the applicant is willing to work with that. You know, they've been really great to work with, so I don't anticipate there'll be a lot of questions, but if something does come up that conflicts, I guess we can always discuss it later.
I just wondered which one's the governing document, which one trumps which, and so the Board of Supervisors has already set out terms.
Right.
And we have the ability to legislate. Therefore, whenever we legislate is the standard, I would think, right?
Well, yeah, legislate means you change the code. The one thing I really appreciated about the Board of Supervisors was, they had that question rise, should they give this to the Board of Adjustment? Iowa law provides that it should go to the Board of Adjustment, and I thought that was a gutsy move. I think that followed the law and gave them a chance to look at it, and that's the way it should be done. I think some of the things they've had here, they've approved the permit application, which is many pages long, many things were approved, and these are just exceptions, that they wanna say, well, let's just kind of work that out, and so they try to work out the terms with the developer. So I think it's gonna work out okay, but it's a valid point. There may be a little confusion. I've read through the development agreement. Actually, the applicant was very liberal in the development agreement in giving you things too. So they seem pretty reasonable. I don't know if they're gonna raise things that they haven't already, so.
So I'm saying if there is a conflict, can we say that the development agreement overrules? One of the documents is that overruled.
Which provision are you referring to? Supervisor?
Is it the one where they come back if they wanna tell their turbine to meet or the board, is that the provision?
I'm asking which provision in the development agreement he's referring to.
Yeah, that's, I didn't know if there was something to do with that, cause that was the question.
Mark,
Mark,
did you hear what he
here.
said?
Which provision are you
Yep,
referring to?
I'm looking for.
Oh, okay.
Give me a minute.
If I remember.
Do you want a paper copy, Mark? It might be easier than your phone.
Do you have the resolution too?
I do, might take me a second, but yeah, I've got the resolution too. Paper's got a little out of order, here's the development agreement. Find the resolution.
I think it's discussion was.
No.
Future planning and all that.
Madam Chair, can I approach the bench?
Oh, sure.
I think I can help the lawyers. So it sounds like what we're trying to do is determine that it won't be any greater than 600 feet,
Yes,
okay? And if it's gonna be above 520,
yes,
that you require that they have a study.
yes.
So you should probably put it in there. I'm saying all that, I'm talking about the wording to get there. If you go over 520 feet, require them to give the affidavit or whatever it is, and then if it's approved one, they just come back with that information, not having somebody else to go back and validate, oh yeah, it was approved. If it was approved, you take that at face value. Does that make sense? Yeah. Yeah, that's it. Just wording it in such a way that it doesn't require multiple steps.
Right, that's how we have it drafted, but Supervisor Dolan is saying that it has to go back to the board of supervisors, and
Well,
I'm not sure where that's at.
Right, we did a lot of.
Yeah, I understand.
I just want to make sure we make it as simple as possible so it doesn't.
Yep.
Or we just say that it comes back to the zoning administrator.
I'm comfortable with that, if we need to,
I didn't know
the
if
zoning
it was-
administrator and the board of supervisors, we can certainly do that.
They make you feel better.
It's in the plan where it could be known, nullified if this board
Doesn't approve it.
rejects.
But it's not coming back to the board.
Right, it's just gonna go to zoning administrator.
The language I'm looking for is around that section, is what I'm talking about. We negotiated a lot of things, and that was part of it. I can just tell you that that's about where it's at, and I can't even find that in the agreement.
But it's around number 9, I think. Section 9.
Once they've established use under all zoning certificates, the zoning administrator shall be directed to take no action.
He's fine with it, so.
For the resolution. Doesn't have anything about the BOA to say.
Which section?
I thought it was.
That's what we agree.
Yep.
language that any updates to the project after tonight would go back to the Board of Supervisors. We are not saying that we wouldn't still go back to the Board of Supervisors and update them with any changes to the project. This would just require us to go to the zoning administrator in addition to the Board of Supervisors. So that is where we are. We don't think that we need to have additional language in our conditions at this time, unless the board feels differently.
No, I just wondered how we should state it, approve this project with conditions and as stated in the resolution? Or what is the best way?
Board of Adjustments resolution, because there's another resolution out there with the supervisors.
Correct. The Board of Adjustments, we would be referring to the resolution being passed today.
Is that specific enough for the lawyers in there?
This almost like, what the way it'll appear in the minutes, resolutions has got more details. And I can reread it if you wanna, because it's been amended several times if you want. But I think if you want to do it, just say that somebody moved and seconded, resolution as read by the attorney to the Board of Adjustment. And it was approved this day, like day blank, you can take your vote by whatever word it is. Find out who moves it.
As he stated it, do I have a motion?
I'll make that motion.
I'll second it.
Scott. We're gonna do roll call one more time. David.
Aye.
Nancy, Joe. And Scott.
Aye.
And John.
Aye.
And I will be an aye as well. Okay, there was I'm sorry, I didn't allow you the chance to speak when you had asked earlier. Is it still pertinent what you wanted to say?
I'll catch the individual.
Oh, all right, okay. I apologize, we just had a lot going on.
He let me know it wouldn't have affected your vote, I don't believe, it was more.
Okay, okay. And so, I think that is it. I would entertain a motion to adjourn.
I make that motion.
Nancy, Joe. Very good.
Yeah.
All in favor, say aye.
Aye.
Opposed, nay. We are adjourned.
9:21. Thank you guys so much for your time and effort on this. Thank you everyone for attending.